sending the money.
We're in this matter. Sorry.
Confirm the order and dismiss. Yeah.
Dismissed. I court also confirm.
Grateful to you.
Lord, in this matter, in January, your Lordship are directed to be listed after 4 weeks, Miller. This is home buyers matter, Miller. And we request you, Miller, to list this matter because it is home buyer who is suffering.
Yes, but it can be taken only after the CP now.
Whatever date.
I appear for the respondent, my lord. Whenever it's convenient for your lordship.
Specific date, Miller, if your Lordship is kind enough.
After you make your work,
Lordship, date.
Great.
Milled's last order was to list after 2 weeks. The matter has not been listed, Milled's. 7 years and 6 months of custody already undergone, Milled's. Any date?
Bail,
Yes, Milled's, for bail. Milled's on Monday, next Monday, Milled's.
Monday, Friday, they will do.
Wait for your lordships.
My lord, may I mention a matter? I want to hand over this order first, my lord. This is after notice matter, my lord. This was listed last before you. My lord, as per the order, the bail was pending in High Court. My lord, the bail was granted on 12th by the Honorable High Court. And on 14th, a fresh FIR registered against 13th. And another fresh FIR registered against, my lord. Mr. Dave was appearing in the matter, my lord. I have moved for interim bail and I'm praying the listing of this interim bail as well as writ petition on Friday, my lord.
My lord's order needs to be rectified, my lord.
You must thank our request to the bar.
Yes.
Otherwise, Mr. Dave would have been here.
My lord's order needs to be rectified, my lord. Lord, this is a child care leave matter, my lord. Your lordship allowed it, my lord. But the inadvertence is it has been ordered to be placed in next week, next month, my lord. I had prayed for order in the next week, my lord. My matter will become infructuous, my lord, if it is not listed before 9th of September, my lord.
With your lordship's permission, your lordships, the NHI SLP.
Yes, Mr.
Yes, my lord. Madam, this is the SLP civil, my lord, with the diary number 45992, my lord. This is the demolition, my lord. It has to be today on, my lord. So, and the compliance report to be filed on the 20th, my lord. So, any date tomorrow or day after tomorrow, my lord. Yeah.
Yes.
With your lordship's permission, may I mention?
Well, may I be permitted to mention, my lords? My lords, this is a review petition which has been filed on the 6th of August, my lords. The order, the impugned order, my anticipatory bail has been set aside by the order date 1st of August. The order got uploaded on the 5th of August. On 6th of August, I have filed the review petition. The registry has taken on record on today itself. I have been asked to surrender it within 3 weeks, starting with effect from the 1st of August, which is lapsing on the coming of the 20th. And this is the urgent for the review petition, my lords. May kindly get it listed in 2 days because it is getting lapsed on in coming 2 days itself, lords.
I mentioned it earlier. Friday. Review petition. You will circulate details.
So Lordship, I am seeking to mention matter is coming out on 3rd of August. So Lordship, I have filed implement application. My application we also listed with matter.
With my lord's permission, may I mention my fresh contempt petition? This court, while dismissing the developer's SLP, had injuncted the developer from not selling any fresh apartment units. Thereafter, while my matter is pending before the Bombay High Court, while my writ petition is pending, the developer has continued to disobey the orders of this court and is selling the fresh apartments. I have filed my contempt petition. It has been registered for over 2 weeks, my lords. But for some reason, it is not.
Your lordship. Your lordship.
Let them complete it. Yes, Mr.
My lord, this is an individual matter. My lord has already passed for reimbursement of the back wages to the petitioner. Contempt petition is then filed. Unfortunately, my lord, board is so heavy that it is being listed on Tuesday. So that's why it is not being taken up. Now there is no dates is also being shown. My lord, may any Monday, Friday, any date, my lord, any Monday, Friday.
Yes.
Lordship may permit me.
So grateful, my lord.
Lordship, the NHI matter out of Kerala is listed at item number 40 before your lordships today. I appear for the concessioner. We have also filed the SLP.
Mr. Rodgate appeared that day.
Lordship, my request is that the SLP of the concessioner also be listed along with item 40.
Who will follow what happens in the solicitor's matter?
I just pray that it be taken up along with item 40.
Okay.
Your Lordship, permission to mention a fresh matter. Your Lordship, it's an SLP concerning a surface matter. The petitioner has made all the payments under the OTS timeline. However, it is stated that the bank is taking the physical possession tomorrow. Your Lordship may list the matter urgently, Your Lordship.
With my Lord's permission, may I mention a habeas corpus matter we have filed, Your Lordships, today because I've been taking, my 2 sons have been taken into custody. One is minor, one is major on 15th of August.
Taken in custody by whom?
Your Lordships, police, Your Lordships took it by, and thereafter when we are going to police station, they are not informing, they are saying they are not in police station. It is a Meerut UP matter, Your Lordships. There are incidences where police has been, Your Lordships, getting into unhuman treatment, Your Lordships, and there is apprehension.
Why did you go to the Allahabad High Court?
Your Lordship, because of reason, Lordships, they have been arrested on 15th. Yesterday, I come to know they are not in police station.
They have been arrested from where?
Your Lordships, one has been taken from my home.
Where? Where is the home?
Meerut, Your Lordships. Your Lordships.
Why don't you go to Allahabad High Court?
Your Lordships, the impediment is there, Your Lordships.
What is
because
the impediment?
Your Lordships, 2 days time will go and my sons are already 3 days because the courts were closed, Your Lordships. And Your Lordships will protect me on.
Allahabad High Court is closed today.
Your Lordships, it is open today, but Your Lordship, from Meerut, if I go, it take 12 hours, Your Lordships, and it has taken some more time. I have overnight filed this, Your Lordships, only because it's a habeas corpus, Your Lordships.
Yes.
This is a petition for regular bail. I have been in custody for almost 26 months now. And my lords, my case is that the two punch witnesses have already turned hostile. The state has filed counter affidavit stating that there are 16 witnesses, only 7 have been examined. The trial is likely to take a long time. In fact, my specific case is also that the case of the prosecution is that the drugs were seized from the tenanted premises of one individual by the name of Hargobind. Now, he is not even cited as a witness. I have a prima facie case for grant of bail. Your Lordship, you should notice on the 1st of April.
The commercial quantity, my lord, is 20 grams. The commercial quantity which was recovered was 12,800 grams, my lord.
My lords have held that even in fixed.
What is the commercial quantity?
My lord, 20 grams.
20 grams?
Yes, ma'am. Yes, my lord.
12,800 grams? No.
Yes, my lord. 12,800 ml.
12 liters?
Yes, my lord. 12,800 ml converted to grams is 12,800 grams.
Yes.
No, from the house, there is 2 cartons of injections, buprenorphine.
12 liters or 12.800 liters or 12,800 liters?
12,800.
12,800 grams, my lord.
Grams. Well, as the premises from which it was seized, that person is not even cited as a witness in the charge sheet. The premises from where the alleged.
What is the stage of the trial?
My lord, eight witnesses have been examined out of 16.
Out of?
Out of 16, my lord.
It's likely to take a long time.
Taking into consideration the nature of allegations, we are not inclined to grant the bail at this stage. However, since more than half of the witnesses have already been examined, we request the learned trial judge to conclude the trial as expeditiously as possible and preferably within a period of 6 months from today. So in the event the trial is not concluded in the appropriate period, it is not devoted to renew his request.
Okay.
Please, my lord.
My lords, this is a bail cancellation matter in which this honorable court had directed to conclude the trial within 6 months. But the trial was not concluded, therefore the co-accused were granted.
The bail granted should be cancelled. Dismissed.
My lords, just the 6 months, the delay was because of their own violation. This was nothing based on part of complainant or the prosecution. And they have criminal backgrounds and there is a threat to life.
Thank you.
Obliged, my lords.
May I please, your lordships?
Yes.
My lords, in this matter, my lords, the state has initiated a fresh investigation, my lords, under Section 3 of the Gangsters Act on the basis of the very same facts on which my previous FIR under Section.
Issue notice within about 6 weeks. Right. Since the petition has already been granted bail, what the offence is punishable under the IPC. The present offence, they are under the 50 Gangsters and Anti-Civil Activity Prevention Act 1983 on the basis of same allegation. We are inclined to grant it for it is there today.
My lords, may I pray for interim protection? Lord?
Already granted.
I'm grateful. I'm grateful.
Please.
Come. 7-8-9.
Yes, Your Lordships.
It's an office report reflects that, Your Lordships.
Civil
Civil appeal number 2773 of 2025. Your Lordships, on so far as the merits is concerned, Your Lordships, I have taken instruction. Instead of reinstatement, Your Lordships, we'll be
please. First, we'll decide the issue with regard to tenability.
Execution proceeding is pending, Your Lordships. He has claimed for back wages 25. That's a problem. Interest is accruing, Your Lordships.
Compensation you are willing to.
Your Lordships, I have taken instruction. In the first round, he was asked. We were asked to pay 50,000 compensation. But since many years have gone by, I have taken instruction up to 5 lakh rupees. Your Lordship will pay compensation. He has worked for only about 14 months. Your Lordships.
The petitioner states that the petitioner is willing to pay compensation, the sum of which 5 lakhs in lieu of the in lieu of registration. Correct. Stay of impugn order on the condition that petitioner deposits an amount of which 5 lakhs in his court in a period of 6 weeks.
Oblige. Some refiling delay.
Condone. On be informed that you will be entitled to avail the services of the legal services authority.
Right.
Yes, Mr. Nagpur.
The impugned order contrary to the earlier division bench order.
Contrary to?
Earlier division bench order, Munat, your Atma kindly come to page 4, Munat.
Right. Issue notice, written about 4 weeks.
May serve on the standing counsel, may serve on the standing counsel, so the date may be. He has got only short period of rest of the service, Maharaj. He has got only rest of service, very short period.
That's it, 4 weeks.
Great, very good.
Just in item application for restoration.
Item?
Dismiss, my lord, 17/4/25.
For restoration.
My lord, for restoration.
We will restore, you argue the matter. On merits.
May have tomorrow, my lord.
No.
The only short issue is whether the need of the.
It is bona fide or not. Landlord is the best judge of his needs.
Right, man.
And the law has now, the law has turned upside down now.
During the evidence, my lord, he has stated at page 64, my lord, that he, at that time, my lord, he was doing MSc in Delhi. Right now, my lord, he along with the entire family settled in Delhi, my lord, as per my instruction.
If you want some time to vacate, we'll grant you.
I haven't talked to client,
we will dismiss it.
Grant me at least a year, because it's 1952.
6 months is maximum.
Since 1952, he was.
6 months is maximum. If you want that, we'll grant you, otherwise dismiss it. We'll grant you 6 months. But we are not inclined to entertain the present petition. As such, the petition is dismissed. However, taking into consideration the fact and circumstances, the period is, the petition is granted 6 months period to vacate the premises. on punishing an undertaking to this court, the formal undertaking.
Obliged.
Please, Lord. My Lord, can I request my Lord to kindly have page 71? My Lord, this is the order of this Honorable Court, the judgment passed is this matter, remanding the matter back. My Lord, can I request to stay as well, please?
Stay of the proceeding.
Sorry? Sir?
Stay of the proceeding.
No, sir.
My Lord, may I request to see kindly page 35, my Lord. This is the express order of this Honorable Court that petitioner will implement the order of the Honorable Single Judge within 4 weeks from today, my Lord. This order was not implied, my Lord, as well as there has been a stay on the contempt proceedings, my Lord. My Lord, I am 85 years old, getting nothing, my Lord. I did a service of 34 years for the UP government, my Lord.
To consider that the contempt petition is pending for a long time, we are inclined to request the High Court to set the contempt petition as expeditiously as possible and within a period of 3 months from today.
High level.
My application for setting aside the ex parte decree. I was in jail, my lords. Admittedly, I was in jail. I said so in the, it was served through the jail, my lords.
Then your relatives are not there outside.
My lord, there was no one there through the company. I was served through them. And this person is not even, he's charge sheeted along with me that he never paid this amount of money. Now he's seeking an execution of that, my lord. On merits of the matter, 390 days is the delay. And this entire matter gets decided after that I come out of jail, my lords. Kindly consider it that it may be sent back and please see it on merits, my lords. And he's charge sheeted with me, this person, that there is fraud that is played.
So both of you are celebrities.
But kindly consider.
Notice.
Lordship.
Return of court.
Lordship may stay the execution, my lords.
Until further order, sir. The execution proceeding will take.
I'm grateful, my lords.
My lords, the DGP consent for the states of Punjab, my lords, prepared a seniority list, my lords, which was challenged by the petitioners herein by the way of filing a bunch of writ petitions, which was got allowed in the favor of writ petitioners. My lord, thereafter, the states of Punjab and other respondents, private, my lords, preferred an LPA which is pending for last 2 years, my lords, now. And if my lords may kindly have page number 80 and 82, the LPA bench of the Honorable Division. My only, my lords, request before, my lords, would be that since there is status quo order, my lords, by the way of passing a non-speaking order, page number 80 and 82, let my LPA be decided in a time frame manner, my lords. Since we have, my lords, succeeded in the writ petition before the land single bench, by the way of passing a 38-page, my lords, order in favor of us, my lords, and in the LPA status quo has been maintained to be, order to be maintained.
I have taken to consideration that the LPA is pending for a period of more than 2 years, that there is an interim order operating against the petitioner. The High Court to decide the LP as expeditiously as possible and preferably within a period of 6 weeks. In the event the High Court is not in a position to decide the LP, the High Court is requested to at least decide the question with regard to continuation or non-continuation of an interim order after hearing the parties.
I'm so grateful, my lords. My lords, a liberty may kindly be granted to me to revive the writ petition, my lord, to revive the SLP if it is not decided, my lords, in 3 weeks.
We'll decide, don't worry about that.
Obliged, my lord. So grateful.
Well, it's in 17. I am the applicant, state of Punjab. May I just tell your lordships?
My learned brother's order.
Yes. May I tell your lordship why? Just give me 2 minutes. Your Lordship, I am going to follow the discipline of your Lordship's order. I'm sorry.
Say that let them continue till the recruitment.
That's all. That's all.
My lords, two things, my lords. One is
Only one
that
sentence
this-
before he speaks. Only one sentence before he speaks of my application. Then I won't get the chance. Your Lordships in West Bengal, where I had the privilege also assisting my lords, passed an identical order as a transitional period. The reason my lord should pass the same order here, I'll give the order, is 913 people are there in the seat from 2021. Your Lordship's order came on 14th July. Even the current July academic session has started by then. It is not your Lordship's intention to leave all these things headless or occupantless. Therefore, my lords, and we will complete it within a schedule which we will present to your Lordship, very strict time schedule, maybe 6 months or 4 months, I don't know exactly. The state government will give a 6-month schedule.
In accordance with the UGC guidelines.
I beg pardon?
In accordance with the UGC.
In accordance, this time naturally.
I was going to request two things. I was going to request only two things. One is
Just see the order of West Bengal for 30 seconds. Just see that order.
I have the order.
Official order.
The order.
Kindly give the order.
I have the order.
Give the order. Why don't you copy the order? Because that should be well as your Lordship's guidance in this matter also.
Yeah.
Your Lordship said if you don't comply in so much time, then the order is vacated. And made it time bound, with affidavit.
Order can be passed here
Now,
also.
we are inclined to accept, Chief Justice got it, Manoj? Justice
And more than
Anjari has got it.
25,000.
One second, sir. We are inclined to accept the prayer made in the present application insofar as it relates to assistant teachers for classes 9 and 10 and 11 and 12 not found to be tainted. Now, fortunately, in this case, no taint alleged, forget found, no irregularity alleged, nothing hanky-panky alleged. And Mr. Nidesh Gupta's clients are those people whom I am instructed are already in situ. They are guest lecture faculty.
Yeah.
They are not displaced. It is not that Mr. Nidesh Gupta's client will be hurt in any manner. They are continuing. So this is, and there are also gives the whole schedule below that.
I have only one submission to make. My lords. One is
Before my friend will not respond, only one more thing. Lord, I am appearing for the people who are already appointed. In the main judgment in West Bengal, you are also, because there is no taint as far as we are concerned. Lord, we participated in the selection committee, got selected. In the main judgment in West Bengal, your Lordships also said that in case we fail here, we can go back to our old job because there were several of us were working earlier. We can go back to our old job with Lee, and that was there in the main judgment.
How can we do that without hearing?
So it was done by.
No, probably it was done. But how can we do that without hearing the persons who would have been appointed in your post?
No, so Lord, even your Lordships have said even supernumerary posts may be created. Just have a look at this order, not in the main order. Lord, we are not to be faulted. We are, some of us are overage
That is the
also. So there is a separate application by us also. Then your Lordships can hear me on this application.
This should not be a ground for anyone to claim seniority. My lords. That must be made very clear. This is being done by your Lordships only in order to avoid a hiatus.
But they again get selected. They cannot take these periods.
Yes, but in no consequence, in no case should this found a claim of seniority. My lords.
Lords, I have one short submission. My lords. Not only later, my lords, right now as well, my lords, Dr. Singhvi fairly states that we are also continuing, my lords. Please say that our apprehension is that in the garb of this order, we will now be removed. So please say that.
Those who are continuing as temporary hands cannot be.
Yes, please say that.
And in my application, Lordship, I have it after notice because there are some other issues, Lord, which are slightly different from. Lord, your Lordship will kindly appreciate, Lord, if I have become overage or if I am, Lord, a PWD physically handicapped candidate, Lord, and I am now not in a position to get anything else, your Lordship, I'm not at fault, Lord, for what the state has done. I participated in the selection process and I was selected on merits.
They filed this petition before the selection.
No, but there was an interim. No, Lord, there was a division bench order in my favor. Your Lordships also passed an interim order saying that all the appointments will be, the appointments are protected.
Yes.
There is the schedule,
It's only one
affidavit. You have to file an affidavit as directed in West Bengal. The state will file an affidavit, the schedule, etc. That's
Yes, of course.
terms.
That I am saying so much.
Here they were 25,000 odd. Here we are at about 1,000.
Just one last request.
We are not saying that if they don't complete within 6 months, then all have to be sent off. Because it is in the interest of the students.
That's right.
But they should complete, they should complete within the schedule.
They will.
Milords, only one last request, Milords. Whoever is actually working must be paid. We are not being paid. 122 of us.
Not that is a different cause of action altogether.
That is not this.
And my lords,
They challenge something and.
even in your lordship is right.
Actually, they all participated in the selection, not got selected and then will not challenge. Your lordships have held that these kind of challenges are not.
Trying to give us time. That's the main thing.
May I just add, my lord, we have also one application on behalf of candidates who are working and whose selection has been set aside. In my application, my lord, I have made 1 or 2 additional prayers, my lord, which is that I had resigned from my earlier assignment. And if I had resigned, my lord, in the West Bengal matter, your lordship have allowed those
We already heard this, Mr. Vikas Singh on that.
I was.
But we are not inclined. Yes.
So your lordship may then permit me to withdraw because I may get selected. This problem may not arise today. So your lordship may permit our application.
We say that we have not said anything about.
Yeah, very well, very good.
Those applications then.
And states is being allowed, so Lord, for the time being, will continue.
I'm concerned about the states I am.
And my lords, no seniority will be claimed even in even during
Already somebody declared that we agreed.
Yes. Your lordship passed the order of the states IA 1452.
States
IA is 1452 of 25. I'm only concerned about that IA.
Others, your lordship may allow.
Then order will be passed.
Deeply obliged. Deeply obliged.
Lord, in 18, there is an application to withdraw, but there is a small problem, Lord.
Well, it's our application. Sorry, I couldn't reach that side.
In the interregnum, Lord, what has happened, your lordships have created or constituted a special selection committee, not as per the law, for the purpose of pro tem Lord members. Now, if they withdraw, Lord, ultimately, because there is an interim order under which your lordships created, so let them, Lord, follow the law and appoint the members and the chairman. That's all that we want, Lord. We don't want.
I don't know what my colleague is appearing for.
No, I filed an application. My application is.
Who are you?
I am Lord. I have an industry here, and I am also Lord an entity which is
But if
regulated.
they want to.
I'm only Lord
If
because there
they
is
want to withdraw their equity, how can anybody?
Lord, because in the interim your lordship has passed orders. Lord, what will happen to that? Pro tem members are working, Lord, who are not Lord.
But continue till regular appointment is.
So I'm only your lordship will record their statement. What difficulty? Let them make the regular selection of chairman and then the chairman.
Their reputation.
Lord, please appreciate. Lord,
So who has to be heard first?
This is a matter of public interest. Otherwise,
Yes, but who has to be heard first?
Yes, to
It is the president of the bar should set a role model.
Sorry, I couldn't read this side, my lords. This can be closed, my lords, and pro tem members who are in.
The learned copy was the petition. They liberty to withdraw the.
And make a statement, they will appoint the chairman.
No, not appoint.
Will you permit us?
Lord, she made a statement.
Learned ALD, further submit that. Still, the regular appointments are made after following the procedure as prescribed in law. The totem members who are working shall be continued. But within the hour's time, we will complete the procedure.
We'll complete, my lords. I don't have instructions on that, but now we'll do it, my lords. This
3
was
months
pending.
or
we will not do it.
3 months should be.
We don't know how much is statutory, but some invitations and everything.
Do it expeditiously, my lords. I can assure your lordships.
Learned ALD further state that. The
Statute says 1 month, Lord. The statute says 1 month.
So there will be advertisements and interviews, so we completed expedition.
Great.
Deeply obliged. So good.
Please, my lord. My lords, I appear on item 19. This is a section 11 petition for appointment of arbitrator. My lords, I've only filed an application for amendment, which may not be on record. The notice invoking arbitration, my lords, by some inadvertent error was the wrong one which I added. I just want to replace that. My lords may list it on Monday. I'll correct it and I'll bring it on record.
Is you to correct?
Please, my lords.
Post the matter on Monday.
Oblige, my lords.
Well, if this is the way Vice Chancellor are to be appointed, Mullins, I shudder to think, Mullins, what will happen in the future. See what's happening.
So, Super, we appreciate hearing arguments on the law.
I'm sorry?
Rather than prelude, you tell us what are your arguments.
Yes, simple arguments. Malas, kindly see, Malas, the process is, Malas, the Executive Council, Malas, votes and suggests some names, Malas. And then the matter goes to the court. Correct? And the court then, Malas, suggests ultimately 3 names go up, Malas. And ultimately then the Chancellor, Malas, decides on one of the 3 names. The President, that is the President decides on one of the 3 names. Now, Malas, now what did this Vice Chancellor do, Malas? Kindly see, and the process is, Malas, that the provosts in the court have 1 vote each, and the provosts nominate a person for a vote in the Executive Council. Now, Malas, see page 292, what happens? There are 5 provosts in the court. Kindly come to page 292. Now, Malas, this is an order dated of the Vice Chancellor dated 19th of October, 2023. And Rafiuddin, who is the provost of Habiball, and you also had that? He's asked to hand over charge. Right? He's the senior most provost. Then, Malas, your lordships will find Muhammad Johar, 293, is also advised to hand over charge. Then over the page, Malas, Brijbhushan Singh, another provost, is asked to hand over charge on the same date. All these orders are passed on the same date, 19th of October. Then, Malas, the next one, Sarojini Naidu, hand over, so Shaheen, Professor Shaheen, asked to hand over charge, 19th October. And then, Malas, then the same thing, the next, Shamsuddin Hussain, page 296. So the 5 provosts, who are the senior most, are asked to hand over charge, right? Now come to 297. They are then reappointed. Kindly see 297. These very provosts are then reappointed in the same hall after 4 days, just to remove their seniority by the acting VC, who is the husbandman. Because the 5 senior most provosts are members of the court, and each of them has 1 vote. So each of these 5 votes, your lordships will see right up to page 301, are reappointed on the 23rd, right? Now kindly see the list, Malas, at page, your lordships will find that at 306. 306. Kindly just have a look, it's a little chart. At 306. Now, they appoint 5 new provosts because they made the others resign. These, right. So, Malas, your lordships will find Rafiuddin, Hashmit Ali Khan, Ghazala, Nahid are all now become junior. And the 5 on top on the right-hand side have become senior. Right, Malas? What's the purpose of this? To ensure that these 5 provosts vote for him. Vote for the lady. Obviously, Malas, this is being done to reduce the seniority of these other 5. This is shocking, absolutely, Malas. Shocking. Yes. Challenged, Malas, pointed all this out to the court.
What happened to that challenge?
No, the judge doesn't deal with it. No finding returned on this. He said this is a matter in issue.
Provosts were members of court.
Yes.
The university.
Yes. And each of them have 1 vote, Malas.
But each of them has 1 vote. But even then, both of you got the votes in what you call court.
But that he would be reduced, Malas. The Vice Chancellor's vote and the Provost vote is not counted. She'll be not in the reckoning. Because she'll get only 6 votes. I'll show that also. I've got that also worked out.
You're talking about the executive committee.
Executive committee as well as the court. As well as the court. 1 provost goes to the executive committee, the other goes to the court, Malas, and she's nowhere in the reckoning then. It's only because of the Vice Chancellor's vote and the Provost's vote in the executive committee.
There are 20 members in the EC.
Yes, exactly. So if you reduce these 2, Malas, she is in minority.
So she's got 7.
6. Vice Chancellor's vote excluded and one provost vote excluded. She'll get 6.
No.
She's out.
See, Professor Mustafa got 9.
Yes.
And Professor Hussain, Professor Khatun and Professor Hussain got 8 votes.
Correct. And then the other got 7.
Then again from the 7 they selected 2 more.
Correct. Because she'll be reduced to 6. Mother.
Make it 5.
So she'll be reduced to 6. So she will not be in the reckoning. So she will never go up, Mother. And the same thing happens in the court. And then, brothers, 3 names are not sent. Only 1 name is sent.
When did this voting happen?
I'm sorry?
Date of voting?
Date of voting. 23rd of October. 30th October, sorry. 30th October. And I have set it all this in ground in BBB, mothers. Kindly come to page BBB for a minute. I've set it all out. And he's presiding over the meeting, Mother. In each of these meetings, he presides. Your lordships have held right from Krepak, Mother. What's the consequences of that?
Both the petitioners were before the visitor. So what prejudice was constituted?
No, they were not before the visitor. Names are not sent, Mother. Only 1 name is sent.
No, the panel of 3 is sent to the visitor.
It's supposed to be sent, Mother. Only 1 name is sent.
Professor Rabbani, Professor Mustafa, and Professor Khatun. So both of your petitioners were before the visitor.
No, the minister recommended only 1 name, Mother. I'm just mentioning.
Before the visitor, there were 3 names.
Mother, with respect, she can't be there in the 3, mothers. That's what I'm trying to tell you. Kindly come to BBB. Just kindly come to BBB, Mother. I show fair she can't be there. Just come to BBB, page BBB. Professor Faizan Mustafa received 9 votes. I'm sorry, mothers. I just wait. Lordship got page BBB.
Yes, he will get to move it to the.
May I just show, mothers? May I show, mothers? No, I'm sorry.
There are some factual errors in the submissions. Whenever your lordships permit, I'll answer.
That I'll say so later.
So whether those 5 persons.
Now, kindly see now, mothers. Faizan Mustafa on the right.
Have they given an affidavit that they would have voted against her?
I'm sorry?
On what basis you are saying that had those persons been there, they would have voted against her?
It doesn't really matter, mothers, because she doesn't get the votes, mothers, in any case. Kindly see, mothers, the BBB.
The take were continued. They could have very well voted for her. This is what my lord.
But if the Vice Chancellor is doing this, for what purpose, mothers?
That we don't know. But
Mothers, your lordship knows, mothers. If your lordship tells me you don't know, mothers, your lordship has enough experience to know, mothers, that he's the senior most. He's asked to resign.
No warrant for such assumption.
Well, there is warrant. There is legal warrant. Factual circumstances will result in an inference which is, it cannot be denied, mothers. Now, kindly see BBB. For a minute, see BBB. Professor Naima, Faizan gets 9 votes. Right? Naima, mothers, gets 8 votes. Right? 1 is the Vice Chancellor, the husband. Cannot be included, and 1 is the provost, newly appointed provost. So minus this, she has the least, is only 6, and she's out. The others all have 7 votes. So this is at the level of the EC, mothers. Now kindly, mothers, to come to page DDD. At the level of the court, mothers. Kindly come to the bottom of CCC, mothers, last 3 lines. Out of 84 votes cast, my lords have that. Professor Rabbani received 61, Professor Mustafa received 53, while Professor Naima Khatun received 50. Right, mothers? These 50 include those 7 votes of those provosts, mothers, that were newly appointed. And 1 that is the husband. So the next person at 47, she is reduced to 43. and then she's out again. So you manipulate the provost, and this is the very vice chancellor whose wife Malaj is applied for the job. So Malaj, the very vice chancellor Malaj.
Every person has 5 votes in the EC.
Yes.
Yes, that's right.
These 5 votes can be exercised here or there, correct?
Yes, because 5 people are to be nominated by EC. So every member of the EC has 5 votes. In court, every member will have 3 votes because 3 persons are to be nominated for that.
This total votes, 9 votes for Mustafa, 9 votes for Khatun, 8 votes for Professor Khatun and Professor Hussain, and 7 votes for the others, 35. That all adds up only to 42.
Malaj,
Because 95 is the total votes.
95 is the total. We made a flow chart of the votes. Just 3 things I want to tell you, Malaj, inform your lodges before that, the 3 errors that my colleague has made, Malaj. Firstly,
It
Malaj,
should be exactly.
that are changed is strictly in terms of the statute because the tenure of the provost is 2 years as per the statute, and they cannot continue. So the executive council would have been defective if the provost who had continued longer than that would not have been removed. So that is one submission that my colleague has made. Secondly, your lordships asked him whether this was challenged. Please see the prayers at page 389. There is no challenge to removal or reappointment of any of the provosts. The only challenge in the writ petitions is to the minutes of the executive committee, to the minutes of the court. 389, if your lordships will have my lords for a moment, this is the challenge. So there is no challenge, no provost removal is challenged, no provost appointment or reappointment is challenged ever. Number 3, my lords, the executive council, 19 members are there, my lords. Each member gets 5 votes. We've culled out. So it started with a process of 33 persons who either nominated themselves or who filled in the form for being appointed as VC. 20 of them are nominated or seconded. So proposing or seconding has to take place. That is an exercise in the executive council. Executive council, my lords, then each member, which is 19 in the present case, that takes place on. So your lordships asked also the date of voting. There are 2 dates of voting. In the executive council, the date of voting is 30th October 23. And in the court, there are 84 members in the court, my lords, and the date of voting is 6th of November 2023. And after this now, and your lordships put this question also that both of the 2 petitioners are part of the 3 members who are nominated before for the consideration of the learned visitor. The visitor, my lords, has powers under the statute, very wide powers. The power is to select or to send everything back. They can say you recommend fresh names. The visitor has the absolute power to select. And my lords, out of these 3 names, the visitor picks up for the first time, making history for an institution, my lords. The first woman vice chancellor of this university is being nominated a lady with stellar academic record. And it is being challenged by, and the submissions are being made on factual errors.
Factually.
High Court's finding is there is no bias at all. This is actually parts election and part selection. The process of nomination.
So 1 second, hold on.
And the process of selection finally by the visitor is a selection. Though the High Court did not agree with us also that there is an element of election in the initial parts. But clearly, my lords, these are by votes, these are by secret ballots, and those ballots are put by each of the members.
Namrat, may I answer?
See that flow chart, my lord.
Yeah. See, this 5 votes can be cast in different persons' name.
Yes, my lords, it's like bar council votes, my lords. Your preferences. Who are your 5 preferences?
Yeah, sorry.
Statutory requirement that after 2 years, you cease to be.
It's absolutely incorrect statement. Number 2, Malaj, it has been challenged. What she said and I didn't challenge, please say 366. It's all this is challenged.
But where is it argued before the High Court?
Yes, in the High Court also. 366, just kindly see.
No, in the judgment.
In the judgment, he says it's an issue, therefore it is a debatable issue, he says. No finding on that. When I've given details, Malad, in para 61, at least your lordship should examine the matter, Malad. I don't want to stay at this point. Page 23 of the impugned order. Para 59. Executive Council, third issue. Yes, the third issue is in view of the fact that the meeting of Executive Council in University Court was chaired by Professor Gulrez and his wife got recommended. A change in the composition of the Executive Council about 10 days prior to the proceeding is also relied upon as being illustration of bias. The no finding, and I have set out, my lords, all facts in para 61 at page 366, exactly what I argued before your lordship, my lords. And the High Court has given a finding that there is bias.
Where is that finding?
That finding, my lord, that page para 74, page 27. Last line of para 72. Chairing and participation of Professor Guldez in the process of recommendation. Para 74, page 27. Last lines. Chairing and participation of Professor Guldez in the process of recommendation is held improper. We deem it appropriate in such circumstances to issue a directive to the university, henceforth not to allow any spouse or close family member to preside and participate. What's the point of all this, Mullah? And then see page para 73, again, clause 27, chapter 2, presiding the rules of clearly provide that no member who is likely to be affected personally by any motion, favorably or adversely, shall not be entitled to vote on it. He still voted. Mullah, at least your lordship should consider it, Mullah. In the facts of this case, Mullah, it is clearly desirable for Guldez Ahmad abstained from presiding the crucial executive meeting and Mullah, the influence of the Vice Chancellor. It cannot be said that the husband will not be affected personally by any motion adopted by the House. At least, Mullah, your lordship should look at it, Mullah. This is not fair. Please let the matter be let the law be laid.
And 87. 74 first, since the quorum of Executive Council is 15, whereas 19 members were present and had participated, therefore, no difficulty would have otherwise arisen if Professor so-and-so had abstained and allowed the next man in command as per statute to preside such proceedings. This course would have obliterated any apprehension of bias in the process of recommendation. Well, this 19 select 5. Recommend 5, not select 5, 5. Thereafter, my lord, there is...
But if his wife was to be selected,
yes, my lord,
would it not have been a proper on his part to have abstained from the...
Correct, my lord. My lord, I have an answer, but without going into that. Out of this 5, which includes, my lord, his wife, the matter goes before a court. My lord, it is court is, my lord, used...
Like Senate, it must be like Senate.
Like Senate, which consists of 84 persons. Those 84 persons selects 3 out of 5. And those 3 persons' names goes to the Honorable President of India. Now please come to page 31, para 87. So 84 persons selects 3.
There is only 1 vote for each member.
Yes, yes.
No, it must be more because 61, 53 and 50 are the votes.
Everyone will give.
Question is, how was she selected? That's the question.
Lord, para 31. Lord, therefore, 3 names Lord, selected or recommended by 84-member court of the Lord, university is placed before Honorable the President, and now this is the finding. Para 87, page 31. The visitor under the statute is not, I'm sorry. Yes, page 31, para 87. The visitor is the Honorable President. The visitor under the statute is not obligated to accept the recommendation of the Executive Council and the University Court and has the authority not to accept it and call for fresh recommendations. Presumption in law would be that at the level of the visitor, the proceedings and record would be examined. At the crucial stage of selection before the visitor, neither the proceedings are shown to have any shortcomings nor any bias is alleged. Consequently, the selection of Vice Chancellor by the visitor cannot be questioned. Lord, it's not that I select my wife. Lord,
I'm not challenging the visitor's order, Malad. Where am I challenging? I'm only saying you should not have been there. Your name should not have been there. You not would have gone to the visitor. I'm not saying, Malad, that the visitor did this or that, Malad. I'm not alleging any bias against the visitor, but this is not fair, Malad. This whole process is tainted. At least the matter should be considered, Malad.
Clause change just
I'm sorry.
Clause 12 of the statute, my lords, and please see page 380 for a moment, my lords. Please see the prayers. My colleague, when I said it is not challenged, my colleague pointed out page 366. 366 is some ground. The prayer is the challenge, my lords. Please see page 380. Issue a writ so-and-so in the nature of certiorari quashing order passed by the visitor by which respondent number 5 has been appointed.
Why would I say that?
So and so quashing minutes of the meeting of
Naturally.
Executive Council, minutes of the so and so of University Court, and so far as it recommends the name of respondent number 5. To
I
the-
have to challenge that. What else can I do?
Declaring, no,
I can't be challenging anything else.
removal of
On-
provost. Those 5 provosts never challenged and clause
No, but then the amendments to that effect are there.
Yes, it's all there.
page 366, there is a ground that that has.
And our specific amendment.
Yes.
So averment is there, but the removal of the provost and reappointment of the provost is not challenged. And permit me to show
That's the whole
statute.
point.
Clause 12 of the statute.
Why should I challenge?
Specifically that order.
It is their ground that this was done with a malign intention. So
My lords, it is done
Obviously.
strictly in accordance with the statute. Permit me to show clause 12 to your lordships.
Well, it's at least. Let me-
The statute, my lords, is at appendix. I'll just place clause 12. Page.
Put this on affidavit, Malas.
let us see what is the clause.
Sure.
This has affected the selection. That is.
Of course it has. What else is it?
In this personal capacity,
Sorry?
was the Pro Vice Chancellor implicated in this personal capacity?
No.
Qualified senior?
No, that's all right. I am not seeking any mala fides.
Page-
I'm not finding of mala fide. Well, why should I do that? Why should I do that? Why should?
So the pro vice chancellor,
The husband of.
The husband, Malas.
was he not implicated?
I'm sorry?
Was he implicated?
No. Why would we impede, Malas? Why would?
If you are alleging malevolence against him, then your petition is bad in law for the non-gender of
Sorry, Malas.
disability party.
Parties has him. My home parties has him. Malas. That's it. 340. Malas. When she says something, I accept it, Malas. But its fact is there.
Page 129.
At SLP, if it is not there.
It's there. It's there, Malas. Page 340, it's there. You're tossing to take it.
40.
Yes.
Page 129, my lords passed.
There can't be a better case on facts than this, Manas. But anyway,
Professor Gulraj.
yes, it's there, Manas. It's there.
My lords,
Where is it statute you are hearing?
129, my lords. At page 129, my lords. Foot of the page, your lordships will see. Provost shall be appointed by Executive Council on the recommendation of Vice Chancellor, shall exercise powers and perform duties. And clause 2, a provost shall hold office for a term of 2 years and shall be eligible for reappointment.
But it's
All the provosts had concluded 2 years. If
but
they
it's
had
still further appointments. I've already said so.
Council and the court both, my lords.
Yeah, but then he could have been reappointed on the very same day.
That is correct, my lord. So some of the reappointments have taken place.
No, these 5 reappointments have taken place immediately after 3 days.
Please, my lords.
Yeah.
So reappointment is allowed, my lords. But their initial tenure had gotten over, so they had to be removed and reappointed.
When did their tenure come to an end?
They didn't, Manas, because it was still further orders.
If your intention was only to, appoint persons, other persons after their tenure came to an end, why did you reappoint them after 10 days? Is there question?
Reappointment is permissible in terms of.
No, they're not saying that it's not permissible.
There's no challenge to the provost removal. None of the provosts opposed it. There is no challenge by the writ petitioners also. In the prayer, it's not there, my lord.
In the grounds, it is very much there that this has been done only in order to manipulate the selection. So anyway, you file an affidavit.
Provosts are not parties.
Provosts are not parties.
They are reappointed now. What is their grievance?
Exactly.
The real question
Let them
would be
file.
whether the apprehended bias has materially affected the outcome.
But then one presiding over the all selection process, he was also the chairman of the court also.
Yes.
That's the doctrine of necessity.
What's this?
Doctrine of.
No.
Don't please.
No, but
I'm laughing because
but
necessity certainly is not a
policy.
valid ground for you.
And indecent to laugh at the.
Come on.
If the High Court itself observes
Yes.
that it would have been better for the Vice Chancellor to have walked out of the proceedings and made the next person senior most as a chairman of the.
That would have been an ideal situation, but Lord, he did.
No, normally, even when we sit in the collegiums, before junior at the bar is under consideration, we recuse ourselves.
Ultimately, my lord, thereafter there is a screening by the court.
Looking at it that way, then I was the chancellor of the second petitioner. I should not be hearing this.
No, I'm
I'll
sorry.
recuse. I was the chancellor of Chanakya University when I selected Professor Faisan Mustafa.
No, no, that we are, my lord, we are.
You have no problem, but then when
No,
this is the,
Your
this is
Lordship.
the subject matter,
Lord,
it is only proper that
what,
I.
in that case, I'll put in my reply, my lord, after 2 weeks. Let's see, my lord. Your Lordships, why should your Lordships
Fair enough.
recuse? My lord, we have full faith, my lord. There is no.
But then my learned brother has any reservations.
My lord, I can say, my lord, we have full faith. My lord, even your Lordships have selected Mr. Faizan Mustafa. My lord, your Lordships can take up, and we have no objection. Your Lordships would
No,
decide it, my lord, obviously.
Obviously, only because of this. Now, the question raised here is clearly biased. Biased by bias. So then I don't want to,
This is the real test.
Anyway, we got to follow.
This is the real test for it.
It's for my learned brother to take a call on that. Not to
But this was the real test, my lord.
of which
That your Lordship's participation would not have initiated. That's all I am arguing.
it would not have initiated, but certainly husband's participation when the wife is undergoing selection. It is said that the thing should not only be done properly, but they should also seem to be done properly. Some practices are to be followed.
But your Lordship knows Tata Cellular,
What is Tata Cellular got to do with this?
the doctrine of necessity was evolved because of
But then the High Court doesn't come to a conclusion that the meetings could not have been held had the husband not shared.
support the High Court's judgment by this doctrine of necessity.
Not to place before the bench of which Justice Chandra.
Please, sir.
Not to be placed before the.
My lordship, I'm looking for a passover, my lord.
Why, Javid?
My senior advocate. Passover required. Sir.
You want a passport?
Yes. Okay.
An entire proceeding is decided ex parte.
You are not noticed.
No notice at all. In fact, the order ends, if my what will see page 3, even there's a footnote, postscript which says notice now to the Pollution Control Board. Even then they don't think it's necessary that I should get a notice. It's extremely strange, my lord. And there are two orders in the matter, one holding the OA maintainable without notice to me, and one disposing it by making observations against me. And my lords have repeatedly held that this should not be done. Yet it continues.
Before passing the impugn order, the petitioners were even not put notice. Very well. Put notice.
Could my not stay the
Returnable 4 weeks. I didn't stay of the impugn order.
obliged?
Please, sir. That initiated my lords would be able to, my lord, kindly see, my lord, I
You saw yesterday's time slip in here.
pardon, lords?
You saw yesterday's time slip in here.
Yes.
12 hours. There was a traffic law.
Lord, there was a lorry fallen, I'm told.
Lorry did, it was not an act of God. He fell into a porthole and was.
Because of, look,
Porthole.
can I just attempt to persuade your lordships, my lord? Few more copies.
See, it is not necessarily because of the toll. As my lord the Chief Justice said last time, see, what happens is the road is in disrepair, the entire place. As you said, the blind spots are there. The contractor doesn't put the service roads. That is why this happened. So then, when that is there, what is wrong in the High Court saying that don't take the toll till the road is serviceable?
I am not, my lord, contesting on behalf of the concessionaire. My worry is that the concessionaire under the law, Lord, is required.
That already the Lord Chief Justice has.
Would your lordships, my lord, just have a look, my lord, for my satisfaction. My lord, I also have the video, and my lord, Justice Chandran may be able to, my lord, even relate to that video, my lord. Lord, this is one of the green part, green patch, Lord, is the entire length of the highway for which the toll is being collected. Correct, my lord? This is about 65 kilometers, 64.94 kilometers. Lord, these three red patches are the patches where we are constructing either underbridge or overpass. Correct, my lords? Now, my lord, if your lordships can allow me to show a 2-minute clip, my lord, what is the, can my lord, someone come there, my lords, if your lordship permits. Your lordships will be able to even recognize the. I will extend the date now.
Where is your clip?
Extension very good. So if someone comes, my lord, he will fast forward the irrelevant part. Lord, if someone can come, my lord, my colleague will come, and my lord, he will fast forward. Because I have seen in the morning, some is, my lord, to be fast forwarded. It shows the entire highway, my lord. We need not see the entire highway.
Yesterday there was a picture. The Malayalam, see that 12 hours.
12 hours.
It was because of a lorry broke down. But the lorry did not break down by itself. It fell into a pothole and it was stranded.
Some 15 kilometers it's stuck. 15 kilometers stuck, Manoj. It's entire short is there.
I don't think that would hurt. They can move all our food, we have taken the pins of that. मरते नहीं है Lord, if your lordships can spare only 2 minutes and I request my colleague Muller to.
Here shows only where the toll is there.
No, it would come, Lord. Therefore, I requested my colleague to fast forward it. Lord, this is the regular highway where there is no issue, my lord, on either side. But at some stage,
the photographer would have waited there for quite some time to catch this easy traffic.
We have only 45 seconds.
We have drawn photo.
No, did you engage a wildlife photographer? They have patience. They wait, see when the
for months. They wait for months.
The lordships are right. It's a very good simile, my lord. This is, my lord, the problem area. Now we have constructed service road. Kindly give me the.
Yes.
We have constructed the service road so that traffic can move there. Now, because of the monsoon, we are unable to repair that traffic road. The Chief Secretary has also, my lord, gone into this, and he said that the moment rain stops, you start repairing.
The moment your repairing is over, start collecting toll. Nobody stops you from doing that.
What is the toll for 62 kilometers?
65 kilometers.
65 kilometers. How much is the toll charges for say four wheelers?
What is your toll charges? My learned friend is for concession.
I have not been paying since I became a judge, so I don't know.
He doesn't know.
It must be some.
Neither do I.
150 minutes.
I was traveling to
150.
car.
150 rupees for per car.
150 rupees.
So,
Both ways are
One way on.
so why should a person pay 150 rupees for a road which takes him 12 hours to come from one end of the road to the other end of the road for 62 kilometers?
Lord, I can, my lord, suggest something else.
No, no,
If that-
suppose Maharashtra has prepared a Samruddhi Marg from Mumbai to Nagpur. That it will take only 8 hours. Suppose if the work is not complete and that 8 hours take 80 hours and the toll charges say 2,000 or so. Why should the
Your lordships are right, but your work is complete.
So they are suffering twice. Firstly, it takes them wastes their so many hours. A road which is expected to take 1 hour, they have to travel for 11 more hours and plus pay the toll.
Lord, there is one judgment, my lord, if your lordships can consider that in such circumstances, instead of no toll, let there be proportionate reduction.
What is the proposal? The person is paying. If I pay,
Lord, frankly speaking, I am not convinced, but it's a judgment of your lordship.
we'll see. Let us see.
Kindly see, my lord. Because it's difficult, my lord, to, there cannot be any proportionate reduction because there is no standard of that proportion.
This 12-hour block, probably the National Highway should pay something to the commuters.
That's correct.
For the fuel and the patience.
Some food also to be served on the national highway for in meantime.
The proportionate payment.
Where is that?
Para 23, my lords.
Para?
23. Having said, my lord,
It
but
will
can
be,
you say 20?
no, but it will also be better to read para 22 also.
22, my lord, first, if your lordship can.
Yes.
22. The levy and collection of toll in case at hand is obviously on the assumption that the road is being properly maintained and that for its continued maintenance and upkeep, the users of the road must contribute so that the government is reimbursed an expense incurred by it. In case, however, the maintenance of the road is absent or is significantly poor, as it appears to be the position in the case at hand, the recovery of toll at the stipulated rate would be rendered unfair and unjustified. Having said that, the question is, what should be the extent of reduction on account of poor maintenance of road? It is not nobody's case that the entire length of 26. It's nobody's case that the entire length of 26 kilometers is poorly maintained. At least the report submitted by the committee does not suggest so. There are patches which are extensively damaged and require repair, causing inconvenience to the users. That does not, however, necessarily mean that the entire charge tower toll must be wiped out. The reduction, in our view, should be proportionate to the extent of damage suffered by the road or the failure to maintain the same. Having said that, we must hasten to add that there is no empirical data to indicate the extent of road length and the resultant inconvenience to the users of the road. A certain amount of guesswork is therefore unavoidable in the matter of determining the extent of relief which
Being in combination of 3 today. So. It's a 2 days.
And the one another thing is, this would normally, if there is no traffic, it will take only 1 hour. That distance, 1.5 hours. If there is traffic, I've been regularly going through that way. It will take probably 3
matter
hours.
ends there, Malad.
Then 12 hours means no question of any proportionate reduction.
But I started by saying, Malad, that this may not be the
As Milord, the Chief Justice indicated, we'll leave you to agitate your cause before the arbitration or whatever.
Only one apprehension on my part, Malad. I don't mind, Malad, he not collecting. NHI has no dispute. But under the clause, Malad, this might amount to a change in law, Malad, and he might be entitled, Malad, to get.
So then you have, who is constructing the road, the concessionaire or the NHI?
NHA. The road is constructed. Highway is fully.
What are those bottlenecks? Are they to be constructed by NHA or by the concessioner? Is it a BOT project or only toll project?
No, it is a BOT project. The entire road is constructed. 65 kilometer is constructed. After construction, since there were 3 intersections, we have to, NHI has to make either,
Either NHA has to make it or concessioner has to make it.
no, we have to make it. We have to make it. But now he would say that because of this, I am unable to collect and I will recover it from you.
So whatever is these arbitrators will decide, or the mediation as per your new committee of.
Yes, there's a lot to be said. Now, I'll just go a little slowly, but I'll use the paper books of the Solicitor General so that your lordships don't have to for those other papers. Now, may I just begin by just giving you 2 sets of photographs and then giving you some essential facts which haven't been projected. So when the photographs are being handed over, I want to just place before you, just have a look at the photograph. So set A, which we have just marked, are the stretches of road of the highway. Your lordships have been told that the total stretch of highway is 64.94 kilometers. So approximately 65, a little less than 65. So that's set A. Now set B are, your lordships will see, these are the problem set, where there are disruptions in traffic and bottlenecks. Your lordships have those. Set B. Give one more then. If your lordships have it, Justice has it.
Set B. No, we will share it.
Set A and set B.
Yes.
We will pass it our copy.
Give it to them also.
We are having.
So, set B.
Set B. Now there is a serious problem here on set B. Your lordship has noticed that. But equally, as far as set A is concerned, there is a vast stretch of highway which is absolutely, where the motorway is absolutely usual. Now I want to just set 2-3 things which are very, very basic, essential facts. Please just note. 1, as far as the good part is concerned, I am the person who constructed it and I am the person who's maintaining it even today. Please note that, that's very important. As far as the portions where the bottlenecks are concerned, please note this, this has not been projected. There is a separate third party, note the name, it's on affidavit, PST Engineering. PST Engineering, pursuant to an NHAI separate tender, is in charge of the bottlenecks. I'm just telling you.
Why they put a separate tender?
Yeah, so I'll explain it to you.
Because normally.
No, I'll explain it to you.
No, normally BOT is for the entire street.
Yes, absolutely. So the entire, I'll just explain it. The full thing was for me. So we did that, and NHI has on affidavit said that the motorway was perfectly prepared. There was no problem with it at all. Now what happened? What happened is, your lordship recalls from your experience that on these highways, you cannot have intersection roads at all. But because of local pressure, local communities constructed roads at these 5 points, which are the focus currently. So suddenly this highway had accidents which were taking place, which NHAI has stated on affidavit. Now what was the solution? Because these roads had suddenly come in, the original plan of the highway did not contemplate these roads at all, and it was functioning smoothly. So it was resolved in consultation between NHAI, the state, the collector, etc., that we will have to give a separate third-party tender. So they floated a separate third-party tender. That tender came to be awarded to this particular party, PST Engineering, and PST Engineering is PST. It's all on affidavit. I'm going to show it to you from the pleading. PST Engineering takes charge, and for 1 year now, they are constructing. Now, what are they constructing? They are constructing 4 underpasses and 1 flyover over these areas. Now, what did NHAI require them to do? Because the main carriageway has now been stopped, because that overpass is coming, underpass, it's all dug up. So PST engineering had to first strengthen the side lanes or the service lanes, which they have done. Now, these photographs B, which is the problem area, is with regard to the service lanes in charge of PST, handled by PST, where PST is carrying out the work. PST doesn't appear to be even a party. Now, I am therefore not in charge. I am not responsible for this particular stretch or for this disruption. But the shoe pinches me because the High Court, in trying to find some solution, has targeted me when I am not in charge of this project. There is a third party in charge of this project, and the stretch which I am doing is running absolutely smoothly. Now, this is the background. So the question is, the question I ask myself is, there is a problem. But the problem is, this is not the solution, because I am the one who's invested. I am the one who's maintaining it even today, not these 5 kilometers. I'll just give you a rough area. The affected area is approximately 5 or 6 kilometers. Let us take it. Now, please take up volume 2, which is the affidavit of the NHAI before the court, and how the findings are completely to the contrary. So I will take you just to about 6 or 7 paragraphs. Please directly first go to page 907, volume 2, 907. It starts at 901, but I'll just read a few paragraphs summarizing what I have so far projected. Your Lordships have para 10 on page 907. Now, this is the affidavit first before of NHAI. Do you have para 10? May I place paragraph 10? Yeah, so sorry. Well, it's on page 907 that I am requesting the court to. I'll just place it. Over the years, several patches of highway have been witnessing disproportionately high number of accidents. The cause for these accidents is not faulty design or of the highway or an engineering mistake in the construction of the highway. The highway was designed by persons possessing sufficient expertise in 2005-6. At that time, on the basis of traffic analysis and other relevant provisions, a provision was made for 4 number of grade intersections and 8 number of flyovers or underpasses. The at grade means at the level of the highway. At grade intersections were designed as per guidelines for design at grade intersections prepared by the Traffic Engineering Committee of the Government of the Indian Road Congress. During the stage of construction, owing to severe public protests from local populace, an additional one facility in the nature of a flyover or underpass came to be constructed. Again, the designing of these facilities was done in accordance with the prescribed engineering standards. Today, several at grade intersections have come into existence which were not provisioned in the design of the highway. Majority of these linkages to the highway have been made by the public of the locality abutting the highway, backed by support of elected representatives and even the local governance. These incursions on the highway have been a major conflict point with unplanned and unregulated merging or crossing of local traffic on the highway. Now, my lords, I'm skipping a few paragraphs. Go directly to page para 14, where they identify the 5 locations. Para 14, your lordship will see identification of those 5 locations. Now, please go to para 15. So now I'll read from the last line on page 910. After a detailed study of the local traffic availability of the highway and the engineering constraints and lack of possibility of acquisition of additional land, it was decided by the experts to construct an underpass for the traffic moving diagonally across the highway or build an overpass of the highway traffic. Again, the nature of the work proposed by made at each location was discussed with the state government and informed to the central government. The aforesaid work involves construction of additional facilities on the highway and does not fall within the work of the concessionaire. Please note that. It does not fall within the work of the concessionaire. The need for these additional facilities has arisen post the completion of the construction on the stretch of the highway by the concessionaire and several years after laying the open highway for use of the general public. It was not expected to be performed by the concessionaire under the existing contract. Very important. Accordingly, the National Highway invited bids by open tender method for appointment of a contractor to carry out the new and different works and was eventually awarded to Messrs. PST Engineering Construction. Pertinently, no objection was raised by the district administration or the regional transport officer at the relevant point of time of simultaneous advertising and tendering and or awarding of construction work for 5 locations. That apart, the issuance of the tender notice as the awarding of the work for construction of additional facilities of 5 locations was within public knowledge. The work awarded to the newly appointed contractor, so that's PST Engineering Construction, is to construct an underpass or flyover at these 5 locations. And such work is to be performed within the available highway land. the National Highway Authority of India had an option of completely closing the stretch of highway during the construction period in the exercise of powers available under the Act. However, the same would have caused immense inconvenience to the general public, particularly because the alternative roads, which are not under the management of the National Highway Authority of India, are not capable of carrying large volumes of traffic. Even a temporary closure of the section of the highway where the construction activity was proposed to be carried out would have brought about consequences of major inconvenience. Therefore, a conscious decision was taken by the highway administrator in consultation with the state government not to close the stretch of highway even temporarily, but to regulate the traffic. Now mark the next few words. By diverting the same onto the service roads to be built on the highway land. It was therefore decided that the contractor, please note that, the contractor appointed to execute the awarded work shall first construct service lanes on both sides of the main carriageway for the flow of traffic in a linear direction. The main carriageway of the highway, whose maintenance is under the scope of work of the concessionaire during the concession period, shall be closed for moving the traffic, and the highway traffic will be diverted onto the service roads. It is stated with emphasis that the arrangement was worked out in consultation with the state government, and the district collector and the superintendent of police and the road transport officer were fully aware of the fact that the main carriageway of the highway shall be closed and that the highway vehicular traffic shall be regulated by diverting it onto service lanes. At no point of time was an objection raised in any manner in regulating the traffic. Accordingly, the contractor, now please mark this, that is PST Engineering, first laid a tarmac road on both sides. The available highway land beyond the main carriageway of these locations was limited and did not permit the construction of a two-lane service road. There was provision for making only a single service road. However, care had to be taken to make it as wide as possible. The contractor has constructed a 6.25 meter wide intermediate lane service road on both sides of the main carriageway, which is nearly double the prescribed width of 3.5 meters. Only after completion the work of construction of sufficiently wide single service lane road with due access thereto from the main carriageway was closed for carrying out the works. My carriageway has been closed on these stretches. Now read on. Significantly, the commencement of the work for the additional facilities on each of the 5 locations has been appreciated by the local public, as it would ease the movement and would also reduce the chance of an accident. The petitioners pertinently are not residents of the tract. Now, my lords, with your permission, I'm missing the next 10 lines and reading the last 5 lines on that page 915. All these infrastructure development activities cause temporary inconvenience and even hardship to the citizens. The period of inconvenience varies depending upon the nature and scale of work. However, the works undertaken in the larger public good and in the longer run prove beneficial for the general public. Now, please see para 20. It is true and not denied. See, they're being fair. That the closure of the main carriageway, so I'm closed, my lords, had caused impediment to the smooth continuous flow. The traffic moving on 2 carriageways of the highway in either direction now merges into a single lane on the carriageway and then gets off the carriageway to the service road. The traffic then moves from the service road till the bypass, till it bypasses the exact location of construction work. Then the traffic reconnects into the main carriageway, whereafter it begins to flow smoothly. Then please just have a look at para 22. It mentions now just see halfway through page 917 on para 22. In the present case, the right of the citizen to use the national highway is not defeated. They can still traverse 60 kilometers of the stretch of the highway smoothly. And then please see at the last 2 lines on page 917. Today, the public interest is the need for creation of additional facilities at these 5 locations, as also other locations identified as black spots. Para 24. Now, 24 is most important for me. In light of the aforesaid facts, it is submitted that the contention of the petitioners, that's the writ petitioners, that the concessionaire had closed the stretch of highway or that the closure of the highway and causation of traffic jams is attributable to the concessionaire is factually incorrect and demonstrably suffers from improper knowledge. As mentioned here in above, the work presently being undertaken at these 5 locations are not being carried out by the concessionaire, but are being performed by a third party. They are independent of the concession agreement or the obligations of the concessionaire under the concession agreement. Under the circumstances, So look, it's some third party who's not before the High Court. Now, if there is a problem on service roads, you have to issue directions regarding that third party. This has been removed from my remit pursuant to a public tender given to PST Engineering. Yeah. Sorry. Now just see para 24 minutes, very crucial for my purposes. Just please have a look at the last line on page 918. As mentioned here and above, the work presently being undertaken at the 5 locations are not being carried out by the concessionaire, but are being performed by a third party. They are independent of the concession agreement or the obligation of the concessionaire under the concession agreement. Under the circumstances, there arises no occasion for stopping the concessionaire under the concession agreement to collect the user fee from the vehicles using the stretch of highway. Similarly, there arises no occasion for exempting the users of the highway from paying the fee, more particularly when almost 95% of the highway is motorable and permits a smooth drive. Now, my lords, the last paragraph I want to read is para 30 on page 924. This is also part of the NHAI affidavit. Please go to para 30 at page 94. The report of the district collector focuses only on the spots where the construction activity is being carried out by the contractor. Well, it's not me, by the contractor, for enhancing the existing facility and highlights the issue of traffic congestion at these locations. The report does not state that the remaining stretch of highway is unmotorable or unsafe. It would be indeed paradoxical to report that the entire stretch of the highway or substantial stretches of the highway is unsafe for vehicular traffic and yet permit the use only for making the use thereof. And then your lordship would see the last line in para 30 on page 925. It is reiterated that the Public Works Department, Government of Kerala, has not found the subject stretch of highway either to be unmotorable or unsafe. So, my lords, now just look at the situation. Now look at the operative direction. See the finding first. One finding only. If you just take up the impugned judgment, there's just one finding I want to point out, which is factually at bottom of page 15. Last line on page 15. Yes, yeah. Page 15, your lordship has page 15. I'm reading last 4 lines on para 11. At the same time, it cannot overlook the reality that congestion and hardship currently experienced by commuters have resulted directly from a distinct construction activity undertaken by National Highway Authority of India through separate contractors or on account of failure on the part of the concessionaire to maintain the service roads. Now, this is completely, let's see, just now, your lordships have seen the factual background. Now, I'm just making my submissions. Number one, whenever an equitable order is passed by a court under 226, it has to be equitable to all concerned. Here, I am the concessionaire. I am not responsible. There's a separate third party in charge of these service roads. How can a direction be passed? Because this is 49 lakhs per day. I'm just indicating. That figure which was indicated to you was correct. It's 150 rupees per light motor vehicle, which is the toll which is for this entire stretch. Now, in a situation like this, where I am maintaining the balance 59 or 60 kilometers, I am maintaining, that's with me. There's no problem with that. I need to maintain it. I must maintain it. Otherwise, it will become a safety issue. So I have to maintain it. So my revenue stream, my lords, can't be stopped in this manner when I'm not responsible for the work. Now, just look at it a little differently. NHAI, conscious of this, after application of mine, has entrusted this work for these 5 areas to someone else who's a third party. No directions passed. I checked up. I mean, I may be wrong on this, but at least as far as we are aware, that PST Engineering is not even made a party. No directions issued against them. Now, these are the 5 bottlenecks. So, therefore, I would respectfully submit, in conclusion, 2 or 3 things. First, my lords, any operative and fair direction ought to be or ought to address some degree of responsibility. I am completely not responsible. NHAI says so. In my respectful, we say so. And the High Court doesn't prima facie say that that NHAI is wrong. Then to visit me with the entire consequence. So today, I might just mention the impact already, insofar as I'm concerned, for these 10 days, has been in the range, your lordship may just note, of approximately 5 to 6 crores already. And this is apt to go up even higher if it is allowed to continue. So I am requesting, let there be a stay of this particular impugned judgment. If the High Court wants to earlier or after 4 weeks, consider the situation, after examining, after inquiring from PST Engineering, it may go back and mold the relief. Otherwise, my lord, this is grossly unfair, my lords. It's just because I am there, convenient, somebody else is doing the work, I am maintaining it. And look at the issue, my lords, regarding.
Together and then the chick said, not with me. That you immediately start repairing the service road the moment the monsoon ends.
Because I can't do that. I have no charge or responsibility. Yes, that PST Engineering can certainly do that. I have no control over PST Engineering. He's a complete third party.
May I respond to one?
I cannot, my lords, I can't be blamed for this, and therefore I ought not to be visited with these types.
Your interest is already protected in para 22.
No, it's not protected at all. It's not protected. I am.
You did para 22.
No, I'll place 22. We, however, find that any loss sustained by the concessionaire can be raised with national. Where's the question? I have to maintain the road. I need a revenue stream on a daily basis for those 60 kilometers or 59 kilometers of highway. That is with me. I am collecting the toll. I am maintaining it. Today, my lords, complete absence of.
May I respond for a minute, my lords?
Now, 2 points. Yes, sorry.
Entire repatching of the service road can be done. Only condition is rain is not stopping. That's not the problem.
Now, I want to mention one other thing which doesn't come out in the state's in the NHI affidavit. They took charge. My lords, PST Engineering took charge and commenced their work in April 24. PST Engineering took charge of this area in these 5 locations in April 24. They've been conducting the work, and you will see from some of the photographs that the underpass and all, the main carriageway is obviously dug up. That has to be. So but for 1 year, I'm not even responsible for maintenance or anything. Now, where's the question? So I would, my lords, in conclusion say that the policy of the court is not to foment litigation. You can't drive a party when there are no disputes between me and NHAI to say that now you go and sue NHAI for a difference. That is not judicial policy. That's not a fair approach. And when a party comes before the court and says, look, I am not to blame, NHAI says that, where's the question of adopting this type of an equitable direction? The equitable direction maybe is misdirected, is my respectful submission. And I have to maintain it on a daily basis. So I would respectfully submit, please stay this. Please send us back because the court is still in session of the matter. We'll go back. I mean, these are facts which were placed before the High Court. There is no excuse for not noting what the NHAI says. They have put forth everything threadbare. And you don't pass any directions against the party who's actually conducting the service road and conducting the repairs. As the Solicitor General rightly says, complete within so much time. We will monitor that patch, put traffic wardens, whatever other smooth method for ensuring smooth traffic. But it can't be that the concessionaire, my lord. Yes, yes.
But why would the concessionaire or my lord NHAI for that matter would maintain the remaining 60 kilometers? This dispute is 4 point something kilometers. In
fact, you have been collecting toll all these years. You have been collecting toll all these years, and you are going to continue collecting toll. No, you are collecting toll because you gave it to the auction to him. He has
to have constructed it with satisfaction.
No, but it is on because of the subsequent developments, the opposition of the villagers.
Not opposition.
They started coming on the road intersection.
Intersections, which NHAI cannot prevent.
Then NHAI should have planned it in a better manner. You should have. You should have known how people in Kerala.
No, we don't want to make any such comment. They're very good, perfectly honorable citizens. They have their pressures, etc. We are not saying no.
It's a big town. Kerala is a big town, unlike the other states.
But this is not the problem. 2011. This problem started in 2023 when people started having their own time.
Let's make.
Yeah, let's in conclusion, just one last line. If a party is not to blame, then I don't believe an order under 226 can be issued to a private contractor of this type, because this is my, it's how I breathe. It's my air supply. And suddenly you have just turned it off without with me being blameless and saying, fine, your lordship will consider an appropriate order. I'm grateful.
My lords, there was an order in 9th July 25. I will take lordship to that order. From there, if today we are in 45 days, it would be very pleasant if the NHI come before your lordship saying that we have taken these are the steps and this reduce the traffic. They didn't want to even utter a single word about what step they have taken for 45 days. As my lords pointed, it's not.
Which is that order?
And it's my lords, it's 920.
One fact.
Please, kindly please.
Only a minute. It would help you also. My lord, daily we are doing what is called wet mats on this service roads, my lord, to keep it motorable. But subject to, my lord, the contingency of rain. So, we are
Kindly
doing
come to
that-
page 936.
Wait, what?
This is, my lord, a material which is placed, my lord, in this patch of, my lord, 4 patches of total 4 kilometers.
Kindly come
That
to
is
page
we are
926. At 928. 928, my lords, after the affidavit, NHI affidavit, my lords, this is the NHI Defense Concessionaire. Concessionaire says, I'm not responsible.
You're rightly so, because the NHI has given the work to the GS.
That's it, my lords, but it is the duty of the NHI as per the 600 pages agreement which they placed. Inspect that, what is the traffic congestion, how to be rectified, and they have to talk with them, suspend them, terminate them if they are not able to make it. None of the step has been taken. Kindly come to page 928. The High Court records, we heard the matter at length on several occasions. We also noted the prayers in writ petition so and so, so and so. It's point out pathetic traveling condition that exists in National Highway. Now kindly come to my lord, this is order goes extracting the government reports 930. Paragraph 2. It is 26/6/25. A direction was issued to NHAI. 6 direction, my lords. It's including drainage. It's not as if concession is nothing and no responsibility. The roads are bad, potholes are there, drainages are not going out. The block point where they are constructing there is no deviation provided by the concessionaire. They have to sit together and sort it out. They can't make thousands of passengers to come before for the.
No, but the NHI says that this has all happened on account of subsequent developments. Their work is going to someone else. It is not the work undertaken by the concession.
But that's why, my lord, this project contract itself speaks, my lords, that traffic has to be maintained smooth. That is the obligation of the concessionaire. If the NHA introduces
How can a concessionaire do if that work of an intersection is taken by NHA and given to someone else?
No, that's why, my lord, it intersects each road. So automatically there should be a meeting between NHA and concessionaire. You are interfering with my contract. Please provide a new contractor to give a deviation road. Otherwise, I can't maintain it. Most sort of things happen. Everybody happily collecting the money. Everybody is happily collecting the money. Well, so one more submission.
Lord, we have compelled PST to spend every day 3 to 4 lakhs, my lord, for leveling the road every day, so that it remains motorable. But there are, my lord, issues, my lord. But that, my lord, can't be attributed to me or you.
Well, it's my last submission. Well, it's what the High Court has done. It's after respect of passing a number of orders, the suffering of the public has not been taken care of.
That is all your worry, you are the villager.
No, that's all. Nothing has come out. It's the only argument.
No, that's an affidavit that the villagers have.
NHI wanted to save them. That's why they're making this statement.
Don't make such allegations.
No, kindly similar. Otherwise, NHI has given this.
In fact, when the SG was saying that the rains, you know the rains.
This is my Kerala, correct, it's correct.
I was telling Milord the Chief Justice that I would love to have that power to stop the rains. But
no, it's God's own country with rain. God's own country with rain.
No, it's not because God's own country.
The entire coastal zone, in monsoon is so difficult.
Let's make some. God is troubling you, Lord. Kindly, now what happened, my lords? The High Court has seized this matter. And it's monitoring that suffering. No, my lords,
We'll examine it. Close orders.
Yes.
Only 4 weeks the matter is adjourned. They can.
We'll consider everything.
Very well.
We are aware about what orders passed by time.
And they are entitled to collect if they are with the government, NHI.
Grateful.
Obligement, very grateful.
Grateful to you.
My lords, lighter note, my lords, when we enter into court, gate number E, in the rainy day, 10 minutes, the traffic will be 45. I see number of lawyers, elder, younger, running from the gate, reaching the matter, my lords, for a 1 day rain. In Kerala, for 12 hours, people have to travel.
Delhi, you know what happens once if there are heavy rains even for 2 hours.
Yes, my lords.
The entire Delhi gets paralyzed.
No, that's why my pumping system, water has to be drained. All these things they have to take steps, my lords. They can't blame the natures. Oblige.
Yeah.
Let's may pass the interim protection has been given in that in the order page 390.
Order directed by the same order.
There is no order.
What is the order?
No order. No order.
Page 398 minutes. $16,520, page 398.
So this is not. This is the.
Yes, yes.
Same order.
Same order. 390.
Yes. Lordship, my nomination was cancelled.
We have already discussed similar matters 2 days back. Do you want to withdraw to file anything petition or want the same order? This election petition become, they are not inclined to interfere with it, then yes, sir. पांचों हमारा था तो बाद में देख 2 बजे 2 o'clock. Oh, please continue. Okay. Yes.
Wait, please.
This concerns the Futala Lake in Nagpur. Your Lordships, the pleadings are complete and there's an interim order.
Yes, you argue. Proceed.
Yes, I am. Just pointing out the background that on 25th January 24, your Lordships had been pleased to pass an order that the fourth respondent shall maintain status quo and no fresh construction shall be carried out. Now, this concerns, my lords, on the lake. There is a proposal to have a large construction, part of which is already...
Not a proposal. It's almost complete.
No, so here's what. They claim that, and this is what...
Well, I use the same road when I travel from Nagpur to Amravati.
Well, your Lordships are familiar with how the lake has changed then, because we have in March 2015 filed an application showing the condition of the lake today. It's completely full of filth and sewage. There is absolutely no maintenance of that being done. But that is a separate subsequent point. The point is this. When we come to the High Court and say this is a wetland, it's protected, and there is no question of any construction being carried out, the High Court makes 2 erroneous findings, guided or misguided as it is, by the State Wetland Authority. So if I can take your Lordships to the impugned judgment at pages 5 and 6. Page 5, last sentence, your Lordships have.
Yes.
Yes. It was submitted that as a wetland authority constituted by the Ministry of Environment of the state government, it had taken a specific stand that Futala Lake was not a wetland under Rule 21G of the rules of 2017. I'll show you how this is wrong. But this is the stand taken by the Wetland Authority.
The contents of the affidavit filed on behalf of the Wetland Authority were neither disputed nor controverted. Since Futala Lake was a man-made...
As a matter of fact, that no rejoinder was filed to the affidavit filed by the Wetland Authority.
Correct. Now...
Is it a matter of fact or not?
I'm sorry, that?
The Wetland Authority specifically stated on an affidavit
Yes.
that it is not covered under the definition
That-
of Rule 2(1)(g).
It's
Had you controverted that position by filing a rejoinder?
So both us and the Wetland Authority and the court overlooked this court's order, which specifically prescribed what are the 2 lakh wetlands for the purposes of the wetlands in the country, which specifically covers Futala Lake, and that is in fact annexed here with the petition. So point number 1, factually, it is a wetland. This court's order of 2017, 2 orders fully cover it. If your lordships want to see those orders right away, it's at pages 44 and 54. So the Wetland Authority could never have taken this position, and it's a position that's wrong. It's a position they have reiterated in this court in their counter affidavit, which is also factually wrong. It is a wetland and it's a protected wetland. The second point, page 6 itself, if your lordships were reading.
Yes.
Just 2 sentences on. While the petitioner sought to support its stand by contending that Futala Lake was an identified wetland. Your lordships have that?
Where are you reading?
Page 6, 6th line.
Yes, page 6 where?
While the petitioner, your lordships have that? My lord Justice Anjari has it?
Which line?
6th line, page 6, my lords, impugned judgment.
Yes.
While the petitioner sought to support its stand by contending that Futala Lake was an identified wetland. So we took that position. The Wetland Authority had specifically asserted that it was not a declared wetland under the rules of 2017. There was no reason whatsoever to disregard the opinion of the competent authority that was placed on record. It was then submitted that after obtaining all due permissions and without disturbing the ecology, the activities in question had been undertaken. Now please come, my lords, to page 8, where the findings start, para 8. So the plan, my lords, is for a parking plaza, musical fountain, and a floating restaurant. That's what they want.
And also a gallery for the visitors.
A gallery for visitors. All concretizing, cementing, blocking out the catchment area completely of the lake. Just see para 8.
It's not on a catchment area.
No, the catchment area now is a full wall built around.
No, it's not on a catchment area. I have been, when I was in Nagpur, I used to go for a walk in that area.
Yes.
And it's not in a catchment area.
If your lordships have gone recently for the walk, you would have seen the wall that has been constructed.
Whenever I travel from Nagpur to Amravati,
yes,
I have to travel from that.
Yes. So while this matter has been pending here, your lordship may note that a wall has been constructed. The minute a wall is...
wall has never been constructed. It was sort of a dam. That dam was in existence for ages together.
We have fresh photos of construction. We'll show your lordships that.
This
Page
is a
8.
man-made lake. No, that's our stand as a wetland.
I don't dispute that. But your own wetlands rules provides for man-made lakes to be protected. Nearly half of the lakes in this country and the water bodies are man-made. And that's why this court has given them protection. So I don't even understand this argument that it's man-made, like it makes a difference. Para 8, page 8. We have given due consideration to the respective submissions, and we have also perused the documentary material on record. At the outset, we may state that most of the contentions now urged were also urged when the prayer for interim relief was considered. The said contentions find mention in the order dated 5th July 23, and hence, with a view to avoid repetition, a separate reference to the same is not being made herein. Suffice it to observe that the order dated 5th July was not subjected to any further challenge, and the same continues to operate. On the basis of the material on record, a finding has been recorded based on the affidavit filed by the Director, Environment and Climate Change Department of the State Government, Principal Secretary of the State Wetland Authority, that Futala Lake, being a man-made water body, please mark this, Mala, this is the position that the solicitor is taking now as well. It does not fall within the definition of the term wetland under Rule 2(1)(g) of the rules of 2017. Just if I can pause for a minute here and show your lordships the definition 2(1)(g). It's page 303. Huh? At page 303. Isn't it set out? No, that's okay, but it's there. Page 303, my lords. Just if your lordships,
Page 303.
303 of this volume.
These are new. Part of the interim.
Page 30. Page 303. I'm not troubling your lordships with the substantive rules, it's in a separate volume. But page 303, the definition is set out. Just see it for a minute. Well, let's have the middle of the page. Rule 21G is set out. Page 303.
Yes.
This is from the earlier order of 5th July. In these rules, unless the context otherwise requires, wetland means, and this is the same definition that was there under the 2010 rules, this is the 2017 rules. Wetland means an area of marsh, fen, peatland or water, whether natural or artificial. Please mark this. Artificial. Therefore, if it's man-made, that's the only way it can be artificial. Permanent or temporary with water that is static, etc., etc., etc. And includes, but does not include, please note this, does not include river channels, paddy fields, human-made water bodies or tanks specifically constructed for drinking water purposes, and structures specifically constructed for aquaculture, salt production, creation, and irrigation purpose. I'm hoping that nobody will drink the water from that lake after I show your lordships the photos. So it can't be excluded from this. It is specifically included as man-made structures are included, which is artificial. Now, if I come back to the findings, my lords, page 9, there is about 6 lines, 7-8 lines down on that first paragraph at page 9. Since the field is covered by the rules of 2017, I'm sorry, my lord, the Chief Justice has it?
Yes.
In the imputer. Yes. Since at page 9, about from the end of the paragraph, last 4 lines, since the field is covered by the rules of 2017 and Futala Lake does not answer to the definition of the term wetland, we hold that being a man-made water body, Futala Lake is not a wetland under 21G. So 2 things. First is to say that it is man-made and therefore doesn't fall under the definition. I think there's an error there, clearly from the definition which includes artificials. The second to say that in any case, it is not notified as a wetland. Right, Manoj? Now for a minute, please see page 44 first. This is this court's order in the M.K. Balakrishnan matters. I had the occasion to assist the court on that. Page 44. This is dated 8th February 2017.
44.
Yes, Manoj. Page 44. 8th February 2017. This is the first of 2 orders. This is prior to the 2017 rules coming in. The 2010 rules were there. But the states and the Central Wetland Authority, Manoj, under the 2010 rules, there are a set of brief documents that have to be brought up. If I can just give a little bit of a background. Under the 2010 rules, your lordships are familiar with this even in the forest matters. The states are told that, look, you have to identify what the wetlands are. So you have to come up with what are known as brief documents. Then you go through a process of ground truthing to make sure that from the satellite map, you find on the ground there is such a water body. These are the dimensions, this is the size, etc. You look at the catchment area, etc. And then you notify the wetlands. Now, because the states from 2010 onwards had not notified the wetlands at all, there was now a loophole. Much like in 1996, your lordship said that all the states will identify the forest. There was no steps taken by the states to identify the forest. So therefore, you need to have deemed forests which would get some sort of protection. Otherwise, while we wait for the wetlands to be identified, eventually you'll find that no wetlands remain. As a result of which, if your lordship sees page 50, page 50, middle of the page, the lordships have that? Learned Counsel for the petitioners.
Yes.
50. The Counsel for the petitioners has drawn our attention to an additional affidavit filed by the Union of India on or about 9th September 2014. The additional affidavit contains an information brochure, National Wetland Inventory and Assessment. This brochure indicates on page 11 thereof that 2 lakh odd wetlands have been mapped at 1:50,000 scale. All these wetlands have an area of more than 2.25 hectares. As a first step, the brief documents with regard to these 2 lakh wetlands should be obtained by the Union of India from the respective state governments in terms of Rule 6 of the 2010 rules. We are told that obtaining these brief documents may take some time. We are inclined to grant adequate time for this purpose. The Union of India should follow this up with the state governments and inform us of the time frame on the next date of hearing. The apprehension expressed by Learned Counsel for the petitioners is that with the passage of time, there is a possibility that some of the wetlands may disappear. On a reading of the information brochure, this apprehension is not unfounded. Accordingly, we direct the application of the principles of Rule 4 of the Wetlands Rules 2010 to these 2 lakh wetlands that have been mapped by the Union of India. The Union of India will identify and inventarize all these 2 lakh wetlands with the assistance of the state governments and will also communicate our order to the state governments, which will also bind the state governments to the effect that these identified 2 lakh wetlands are subject to the principles of Rule 4 of the Wetlands Conservation Management Rules. That is to say, and reclamation of wetlands, the rest of it you can ignore. Please come to small Roman 6 at the top of page 52, Milo. From the map. Is it there in the main volume? Page 52, small 6. Any construction of a permanent nature, except for boat jetties within 50 meters from the mean high flood level observed in the past 10 years, calculated from the date of commencement of these rules. And 7, any other activity likely to have an adverse impact on the ecosystem of the wetland to be specified in writing by the authority constituted in accordance with these rules. And then, if your lordship sees the next para, which will give you a flavor of what in the 7 years the governments have been doing. Learned Counsel for Union of India has shown us a chart of proposals, brief documents that have already been received by the Union of India under Rule 6 of the Wetlands Rules 2010. The total number of wetlands covered in this document are 1,683. And please note, well, this is without reference to size. So the government's own wetlands atlas as on that date had 2 lakh odd wetlands which were more than 2.25 hectares. Left to the governments over the 7-year period, they had only 1,683 that they had identified, regardless of size. Many of these proposals, brief documents received by the Union of India contain deficiencies which have already been identified in the document handed over to us. Now please come to page 54, which is the next order. Your lordship may take it from me. I have it at page 39.
39 and extra P1 to the
Yes, I'll show both. Page 39, if your lordship sees, just for a minute, page 39, just come back to that. This is an extract from that atlas, which is referred to and protected by this court's order, page 39. The middle of the page, the slightly highlighted one your lordships have, 101170. 101170, it must be about the 15th or 16th one. It says Futal Lake in the third last column, Phutal. The spelling is different, Futal Lake. Your lordship find that? It's about the 16th entry or so. 101170. So item number 70 effectively.
Futal Lake.
Yes. Now Futal Lake, and in the earlier part of the narration, it says inland man-made tank pond. If you see this page, every one of them are man-made tank ponds. Every one of them. In this one page, there are several of these across the 2 lakh. Now this is taken from that list of 2 lakh, from that atlas. The atlas is massive, which has 2 lakh, a list of that. This is the government's own atlas. So it's not Government of India's atlas, which they have subsequently updated. So your lordships may see it in IA number 35627 of 24, that there's an updated atlas, there's an updated order of this court also, protecting all those updated wetlands as well. So now, just come to page 54 for a minute. Yeah, I'll show them. Page 54, because of this main SLP volume, 4th October 2017. At page 56, actually page 55, beginning paragraph, second paragraph. We have been informed that the wetland rules have since been notified and they are now called the Wetlands Conservation and Management Rules 2017. So this order is passed after the 2017 rules. The rules have come into force on the date of publication in the official gazette, that is 26th September 2017. So this is 1 week after that. On 4th October is this order. 26th September, Wetlands 2017 rules come in. 4th October, this is brought to the notice of this court. And your lordships will see at bottom of page 56. Page 56. Finally, with regard to the satellite images, we are told that the Space Application Center would require between 12 to 18 months to make an inventory of 1,75,000 wetlands as they exist today. We make no comment on this, but request learned ASG to recheck with the Space Application Center since the wetlands are diminishing in our country at a very fast rate. It is very likely that many more will disappear by the time the task is completed by the Space Application Center. We make it clear and reiterate, top of page 57. We make it clear and reiterate that in terms of our order dated 8th February 2017, 2,01,503 wetlands that have been mapped by the Union of India should continue to remain protected on the same principles as were formulated in Rule 4 of the Wetlands so-and-so Rules 2010. These two orders, have been of yeoman service to the citizens of this country when we have gone to high courts, when we have gone to the NGT, when we have come before this court, to say that automatic protection is there for the wetlands which are listed in this atlas, which is a government atlas. Government authorities have come.
How does the High Court deal with these orders?
I'm sorry, Manoj?
How does the High Court deal with these orders?
High Court doesn't. That's the problem.
What was it pointed out?
I wouldn't know. To be honest,
It's a ground taken.
no, Supreme Court's order is mentioned in the pleadings. Show me. I understand it's in the pleadings. I have not found it being referred to in the text.
There are 13 and 14.
But that we have seen in this. But whether these orders were brought to the notice of the High Court, that is what we are asking.
Show me where the order is shown to the High Court. It's there. It's there. I'm sorry. My mistake. Page 9. It's referred to. The OM is referred to and the order is referred to at the bottom of page 9. My mistake. Notwithstanding the aforesaid position on record, bottom of the page I was reading earlier, Manoj, page 9. Page 9, they say, notwithstanding the aforesaid position on record, we may refer to the OM dated 8th March 22 issued by MOEF. In light of the order passed by this court on 4th October in MK Balakrishnan, it was clarified, reiterated by the said OM that the wetlands identified as per Wetland Atlas should be protected as per Rule 4 of the Rules of 2017. Thus, even if Futala Lake is not a declared wetland by the State Wetland Authority, the restrictions imposed vide Office Memorandum so-and-so ought to apply to the said lake. It is in this background that the respondents had been directed to ensure that the spirit behind enacting the rules of 2017 is not violated by undertaking any construction of a permanent nature within Futala Lake. We are inclined to continue this direction with a view to protect and preserve Futala Lake from any construction of permanent nature being undertaken therein. At this stage, we may refer to the affidavit dated so-and-so of MMRCL. The para 13, which is extracted about 8 lines down, it is Now, in the counter affidavit which has been filed by MMRCL in this court, at page 18, which is the MMRCL one, the Metro Rail Corporation.
It is the main executive.
It's filed on 9/2/2024. Please check if they have.
They have it, they're just calling it out.
Page 18, 1/8.
Page 18.
Which one? Oh?
He's passing the wrong.
Which page?
Our four counter
Yes.
Just see para 13, my lords. I'm sorry, I think one of your lordship may not have the correct. It's counter affidavit on behalf of respondent for 9th February 24. My lord, the Chief Justice, same correct one? At which page 18, para 13? No, I don't think that's it. Yeah?
Now he has the right.
Correct.
Page 18, para 14.
Para 13.
Para 13, yes.
Para 13. That a temporary structure. This is their position that they are taking. They say, they use the words temporary. That a temporary structure that is an artificial banyan tree screen for the projection of the 3D visual shall be submerged to the extent of 3 meters during summer period and is expected to be submerged to the extent of 6 meters in the highest of the monsoon. The total height of the structure is 15 meters. The weight of the substructure is 28 metric tons. And the superstructure will be weighing 30 metric tons. No, I think it's a different volume. Different volume.
Respondent number 4 counter dance.
How many counters are filed by respondent number 4?
No, different respondents.
So this is a reply.
R4 filed one.
Counter alage.
Page 18.
Hello, Justice Chandran, that's the correct one.
Yes. There are temporary structure.
Para 13. So I was that a temporary structure is para 13. That is an artificial banyan tree screen for the projection of the 3D visual shall be submerged to the extent of 3 meters during summer and is expected to submerge to the extent of 6 meters in the highest of the monsoon. Total height of the structure is 15 meters. The weight of the substructure is 28 metric tons and the superstructure will be weighing 30 metric tons. However, in order to keep the said structure stable, precast curb stones, each weighing 46.5 kilograms and in total weighing 350 metric tons, has been placed within the substructure. Thus, totaling the weight of the structure to 408 metric tons only, it is submitted that the petitioner's claim of foundation structure girder inside Futala Lake tank being dumped with 7,000 tons concrete stones is false and highly exaggerated. We just took a Times of India news report which said 7,000 metric tons. We don't know independently how much there is and what the weightage is. Now, 408 metric tons, according to them, has been submerged. Now, the reason why your lordships on the first date granted us a stay is because the question was squarely put to the respondents, saying if it is not permanent, then it's clearly temporary. If it's temporary, when are you going to dismantle and remove? To which their answer was,
we have to go by record.
We have to go by record. No. So permanent versus temporary. Let's ignore what happened that day.
That is that on the very first day the order was passed.
Yes. They were on caveat. They were present. Permanent versus temporary was the question. So it is the question today. Permanent versus temporary. Let's ignore that day. Permanent versus temporary is the question because the wetland rules makes it clear that no construction of a permanent nature, your lordship saw. 2G6, which is covered by your lordship's order, makes it clear that that is incorporated and applies to all the wetlands here, whether man-made, artificial, etc. Right now. So if it applies, the question is this construction of a permanent nature? In my view, once you sink 408 metric tons of concrete, we have photographs as well, that is permanent construction and is prohibited and should not be permitted at all. A. B. This photographs, I'm not sure, my lords, when your lordship last visited this area, but if I can hand up, this is from June, last month. This is at the lake. I have never visited, so I don't know where it is, my lords. Your lordships may have the bearings better. Just give it to the other side also. And this is a second set of photos. Second set of photos. Show me, man. Give me one of those. One is this wall that's been constructed. This wall, right?
Yes.
Yes. This is a new wall. And just over it is a lake.
Yes.
Now, if you don't place this wall, then when rains, monsoons come, etc., they feed the lake. Now, unless an examination is done by somebody about what are the water channels, we can't answer this, my lords. Very honestly, we are not experts. But some kind of application of mind has to be done by some environmental authority as to what are the water channels, what is the feeding area, etc., etc. Sorry. Yeah, and water and sewage is separate. But this entire catchment area needs to have been identified. And then the question should have been raised by somebody saying, can you construct a wall? Will it block it? Will it not block it? This is a construction which has taken place now in June. Your lordships can see the second photo with the sand and the workmen, etc.
So there is a status quo.
Yes, we have not filed a contempt. But my friends could possibly argue and fairly that that would not apply as far as what is surrounding the lake. It's in the lake. So I don't know. I can't imagine what they will argue.
The status quo is in all respects.
Yes.
So it is on the
Yes.
lands of pertinent.
So now, except for jetties, boat jetties, no construction of a permanent sort is permitted on any of these wetlands. We have filed an application saying the status quo should not in any way,
6-7.
the latest one, that we'll show later. I have lots of material on record showing that it is a very important birding zone. Migratory birds pass through it. There are 40 varieties of it. There are detailed studies. I'm not troubling your lordships with all that. That's all consequential. But the latest one. This is IA 74161. Filed by us on 24th March 25. Just identify it for them. SA1. Both. This photo is at page 7. Just come to page 7, Manos. Page 7. Please see the photos. These are all photos now taken in March 25, which we had filed. It's an absolute mess of sewage. And at page 11, it's put backwards. Page 11 precedes page 10 actually. There's a local news item saying hundreds of fish found dead in Futala Lake with the photographs. Hundreds of fish are suddenly dying in Futala Lake in the last few days, and piles of dead fish are seen on the banks of the lake. The cause of death of the fish was not ascertained. It is suspected death may be due to increasing heat or chemicals being added to the lake, etc., etc. But whichever way, whatever the cause is, there's a strong belief that it's coming from sewage, and that is stated in the middle column of page 10. But I don't have the answer, my lords. I don't know what the cause is. But I'm saying when you are overseeing it as the government, you should have ensured that this does not take place while the matter is being looked at. Here. This is yeah, there. Leave that. Now, I'll just at page 12 is a recent order of your lordships in that same batch, my lord, that MK Balakrishnan batch, still going on. At page 12, this is 11th December 2024. Your lordship will find that the order starts at page 12. Just see page 16, my lords. Page 16. Prior to 2017, the figures given by ISRO regarding the number of wetlands in India having an area of more than 2.25 hectares was 2 lakh. The latest ISRO data, which is of the year 21, shows that this figure has now increased to 2,31,000. Now these figures have to be checked on the ground. The wetlands rules and the guidelines issued thereunder prescribe the next step in identification. And they have referred to the wetland authority and extracted the rule all the way up to page 21. In the middle of page 21, once again, after 2017, 7 years later, once again, your lordships have directed the states and UT wetland authorities to complete ground truthing as well as demarcation of wetland boundaries, etc., which have been identified for their state by Space Application Center Atlas 2021. The earlier Atlas incorporated in 2017 was the 2011 Atlas. This is the updated one in 2021.
Page 21 you're referring.
Page 21, yes, that middle paragraph. And there is a reference to this 2017 order with reference to the Ramsar sites. Ramsar are under the convention, Manoj.
It is not a Ramsar site.
Yeah, that's not really relevant here. But to show that that protection has remained undisturbed, and we are still waiting for the states to identify all of these wetlands that they have.
So these were identified put under as a wetland and it's pertaining to the state to accept it.
The identification of the wetland is beyond doubt, therefore, that it is a wetland, it's recorded as such, and it has a protection. The fact that the protection extends to construction, which is of a permanent nature, being prohibited, is undisputed. The fact then is artificial / man-made or natural. Is that excluded? That is also not excluded, clearly. The only thing that was excluded, your lordship,
Only if it is for drinking purpose.
Drinking water purpose. Now I've shown your lordships.
Drinking aqua.
Yes. And I understand that this wetland was created by the Gaikwads, is it?
No, not Gaikwad, Bhosles.
Bhosles, by the Bhosles.
Gaikwad are in Baroda.
Bhosles. By the Bhosles hundreds of years ago, and it's been continuing like many of these wetlands you've seen. Now, these are meant for the community, Manoj, and for them to say that, look, we'll beautify it, we'll set this up, at least clean it to start with. Just clean it. That's all we're asking for.
Yes. Who is appearing for? The solicitor you are appearing for whom?
I'm for the state, they would be the contested.
Who would be the project proponent?
So I am for the municipal corporation which granted permission.
And for NMRD.
So I have acted.
Very limited fair manner. All that I have said is that those cables which are highly engineered, cables, the insulation cables, which are lying there are highly engineered, measured, cut to size. They are lying for replacement after being approved by the IMD in the Dispensary Institute, Nagpur. At least they can be replaced. Because why should at least that maintenance, irrespective of what your lordship finally decides on the environmental viability, that's a separate issue. But changing of cables which are insulated cables, why should that suffer in the meantime? I made an application for intervention which was allowed, and that application has been pending. Surely, ultimately, your lordships are to hold that it was a perfectly environmentally viable project.
We are deciding we are working on merits, we will be deciding the matter.
Yes, our limited prayer is that actually for maintenance of the power.
Why do you want to limit it with that? We will decide it either way. Either we permit it or we.
This application was moved by that order of state.
Done it, not.
That is the time I moved it.
And firstly, when there was no stay operating for the High Court for the entire period, the High Court by an speaking order had refused the interim relief by order running.
Which was not challenged.
Taking care of all environmental concerns. The logic 13 and 14.
That we already.
Even if it would have been wetland, this is all which could have been done.
No, but he has raised a question whether it is a wetland.
No, it is not. Please see 30.
So may I only say one thing? The Heritage Committee, which granted permission, was never made a party in the High Court. They have their own reports. None of those reports are challenged.
Not even sanctions are challenged. There is a sanction.
The Heritage Committee.
So who is going to begin?
So your lordship may decide.
No, you decide who is going to defend the project.
It is of Metro.
Please state
Point number 5.
Whatever if your lordship says. I am the executing authority.
You decide who is going to defend.
Your lordships are not available in the second half.
No, we are at 2 o'clock.
You can start. I have some specially fixed matter at 2 minutes for if my learned senior can start.
Dharmadhikar is there.
Yes.
You are appealing for whom, Mr. Naidu?
NMRD. Fifth response, NMR.
NMRD. Who is the project proponent, NMRD or the Metro Corporate?
On number 4, initially it was being executed by Nakuru to now the Maha Metro has taken over to execute the project.
What is the lake to do, Metro to do with the lake?
The project is allotted for execution by the state to the Maha Metro.
May I be excused with?
But that is with regard to the appointment of the ADG of a state, against the guidelines of Prakash Singh judgment of this court.
We are not taking the, we are on the other, that matter is yet to be.
Sorry. I'm so sorry, I thought it was over.
So we will start at 2 o'clock.
My lords, may I? 2 o'clock is another bench.
So we are talking about the partner matter.
Partner, but your bench, the constitution is changed.
No, then that will constitute after we finish our board.
Then it's okay. Then I don't need to mention.
My lords, may I just mention
No
item?
time to make. Yes.
Yes, my lord. My lord, I am.
Password. One or twice.
Sorry,
Yes.
I apologize, my lord, I was not there. But I have to point out, my lord, similar matters your lordships have already dismissed, my lord.
Why 32?
So similar matters, my lord, lordships have already dismissed, coming from the Delhi High Court. I just want to point that out first. But kindly see, my lord, what has happened here.
But why you come directly here?
My lord, Delhi High Court, there is already a judgment, my lord. Delhi High Court already a judgment. But I want to point that out. Just give copies. Just give copies. My lord, this came up to this court. My lord, lordships dismissed the SLPs as well. Okay, 100. One more copy. Lord, the High Court give the SLP orders also. But I give the lordships have, my lord, paragraph 68. The issue which I am raising here, paragraph 68, my lord, is actually was argued before the High Court. That, my lord, the recruitment process had started in 2019. And, my lords, we were told in 2022 that, my lords, now the process will not be continued and you have to apply in the Agnipath scheme. By this time, my lords, we are already age barred. We were selected through the process. And, my lords, all the criteria we fulfilled. Now, my lord, what we are only saying, we are not against the scheme, but we are saying, you know, once the process had started in 2019.
Clearly, selection does not create a.
Like, go down, my lord. But there is a, my lord, human problem here, my lord. Hundreds of these persons who already participated got selected. But there has to be some, my lord, consideration.
Make a representation to the state, central government.
So we'll make a representation, my lord. In case, my lord, they don't consider, your lordships may leave that open, my lord, to come back.
Not under 32.
Not, I'll take my legal remedies against, my lord, that representation, but your lordships may give me that. Otherwise, my lord, what will happen is, since that SLP has already been dismissed, they will say nothing can be done.
What can we do?
Lord, what I'm only saying, there is a point to be, my lord, canvassed. Lord, because ultimately, my lord,
there has to be some consideration. First quote, identical facts.
No, I'll make a representation, my lord.
The Learned Counsel of the petition is liberty to withdraw the petition, with liberty to make a representation to the Union of India. This was withdrawn with liberty as well.
Lord, I apologize, my lord, I was not there.
No, it's all right. This is a third call.
Lord, and my learned friends were not there, my lord. I told them. Grateful. Sorry.
Yes.
My lord, I am appearing for respondent number 4, the Mahametro, my lord, who is executing the project. And, my lord, this responsibility has been given to me, my lord. After the floating deck or floating fountain was constructed. After the floating fountain was constructed by, my lord, by the Nagpur Improvement Trust. Nagpur Improvement Trust means respondent number, I think, 3, respondent number 5. Your lordship will be pleased to appreciate that whatever argument which was advanced before your lordship, entire argument, my lord, lordship will get an answer at paragraph 13 of the impugned judgment. And the interim order also takes care of, my lord, interim order passed by the
13 and 14 are directions, but his argument is that it is also a wetland covered under the in view of the orders passed by this court. And once wetland is there, it is covered as a wetland, then no construction, permanent construction is permitted.
My lord, therefore, my lord, if your lordship sees the wetland rules, the definition which my learned colleague read, my lord, from the interim order, my lord, that is not correctly reported in the impugned order. Lordship may, in the interim order, lordship may have a look to the wetland rule definition and, my lord, the prohibition, which this honorable court, my lord, has imposed under rule 426. What cannot be constructed? I will take your lordship to that, my lord. And the Honorable High Court has dealt in details, my lord, regarding the prohibition. And, my lord, they have been permitted, if there is any violation, they have been permitted to approach the High Court again. Not even the petitioner, my lord. Anybody, public ill-spirited person can approach the Honorable High Court. That is what the Honorable High Court has said in the impugned order at para 13, my lord. Now, if your lordship sees, my lord, the definition of the wetland and, my lord, the prohibition which is prescribed, my lord, his entire contention, if I am not wrong, my lord, his entire contention is that this being a wetland,
No permanent construction can be made.
no construction can be made, my lord.
Permanent construction.
Permanent construction. Yes, my lord. Lordship may have, my lord, first the definition of the wetland, then I will take to rule 4, my lord. Page 7 it starts, my lord. Wetland G.
2G.
G, my lord. Wetland means an area of marsh, fen, wetlands or water, whether natural or artificial, permanent or temporary, with water which that is static for flowing, fresh, fixed or salt, including areas of marine water. The depth at low tide does not exceed 6 meters, but does not include river, channels, paddy fields, human-made water bodies specifically constructed for drinking water purpose, and structures specifically constructed for agriculture, aquaculture, salt production, recreation, and irrigation purpose.
Yes.
My lord, it's an admitted fact on record. Even the petitioner admits before the High Court and before this Honorable Court that this is a man-made lake. Now, my lord, there is a specific averment made by the present respondent, means respondent number 4 and respondent number 5, that this lake was constructed by Raja Bhosle for drinking purpose and for irrigation purpose specifically, and recreation.
Where do you get that?
Yes. That your lordship will get, my lord, to the counter filed by the present respondent at paragraph 22. He has referred to paragraph 13, my lord. It is, in fact, a tank. Para 23, my lord, page 31. Mary?
Yes.
Yes. That the area in question, that is Futala tank, my lord, initially it was tank, it was not even a lake. Futala tank was constructed by Raja Bhosle for recreational and irrigation purpose, as per the record kept in Nagpur Museum for Archaeological Department of Nagpur, popularly known as Ajaib Bungalow, and the same covers 68 hectares of area. It was situated in the, stated in the said record that originally the reservoir was constructed to create a source of water in Telankhedi precinct, which was recreational garden for the Bhosles and site for their prestigious guest house of dignitaries. The catchment lake was formed by damming the Futala stream, which collects water from the slope of Seminary Hills and Starkey Hill Rock, retaining wall from the eastern edge of the lake, and it was a broad, low parapet and circular basin. Futala stream, which is one of the important tributaries of Nag River in the city, became significant to the holding of water in Futala tank. Now, my lord, your lordship will be pleased to appreciate that this has road from 4 sides.
That's what I told Shankar Narayan.
Let me, my lord, 2 minutes, my lord, I'll see.
I told him that I have to use that road when I go from Nagpur to.
My lord, only one side catchment area is vacant. And there is no construction. My learned colleague has not made a statement on in petition before the Honorable High Court or before this court that any
on one side is the
the
Fisheries University.
Yes, Fisheries University.
And the road going to Seminary.
Your lordship is well versed with
that. And the one side is the road going to Amravati Road.
And my lord, your lordship will be.
And those slums on.
Correct, my lord.
Yeah.
And my lord, the boundaries are not just constructed; they are constructed from long back. Now, a fresh, earlier to passing of an interim from, my lord, more than 1.5 years or more than 14 months after an interim order, there nothing has been done because your lordship has prevented everything to be done. not to do anything. From January 2024, my lord, everything has come to a grinding halt. My lord, your lordship must be aware of the fact that even the fountain, my lord, it was inaugurated. And there were shows which were conducted. Now, my lord, this construction started in the year 2019. There was a specific contention. And the present public interest litigation, which was filed before the Honorable High Court, was in 2022, my lord. No, my lord, your lordship may further.
High Court has non-suited them on that ground.
No.
I think that it's a good public.
High Court has not non-suited them. My lord, High Court has kept everything open. I will take your lordship to that. Now, your lordship may now see, my lord, what was being argued before your lordship was. What is the prohibition? Lord, lordship may have, your lordship is having the rule. No, lordship may have, peruse rule 4, my lord. And the relevant rule is Roman 6. Restriction of activities in wetland. Well, this Honorable Court has said that this restriction will even apply to the mapped wetlands because Futala Lake founds place in the mapped wetlands by the state. Now, your lordship may straight away, my lord, the activity which he is saying is Roman 6. 4.2 Roman 6. My lord, may I read? Any construction of permanent nature except for boat jetties within 15 meters from the main high flood level. Mean high flood level. Observed in the last 10 years, calculated from the date of construction of the rule, commencement of the rules, and now what is high flood level? No, high flood level cannot be in dry zone.
Cannot be?
Cannot be in dry zone because there are already walls existing and roads are existing. Therefore, the guidelines which I have filed on record, they said high flood area means the catchment area. It has to be catchment area. Where the ecology will grow and develop, where the birds will come. In the rainy season, if the water goes to level more than what the level is in the actual days, then it comes back after that. So the catchment area of the Futara Lake is totally still vacant. No construction has been done on that. Whatever has been done, my lord, the viewers gallery is, my lord, sanctioned way back in 2019 by the competent planning authority, Nagpur Improvement Trust. And, my lord, the parking plaza is beyond the road, my lord. Parking plaza is beyond the road. And parking plaza is also sanctioned by the by the competent planning authority, that is Nagpur Municipal Corporation, in 2019, my lord. And, my lord, the sanction is granted by the Heritage Committee. All these permissions which are granted, your High Court rightly says so, my lord, all these permissions which are granted, they are granted under the Maharashtra Regional Town Planning Act. No, they are not challenged. Now, a short question which arises for your lordship's consideration is, my lord, can there be a stay or injunction to stop a sanctioned construction? Lord, I put a question to myself, Lord, they have never challenged the sanction till date. The construction is complete, my lord. Now, therefore, there is no statement which can be pointed out that this construction is in a prohibited zone. Now, my lord, coming to the construction. No, I'll come to
Gopal Shankar, one thing. Why did your client not approach when the construction was going on?
The construction started in May 23. My friend says 2019. The dates we have is May 23 when the sanction was granted. So if they constructed from 2019, I don't know whether my friend is getting that date.
What is the date of the sanction?
2019, I think.
The construction started.
Date of sanction is 18/10/2019 for the viewers gallery. It is sanctioned by the Heritage Committee. Is initially granted on 29/9/2018. 29/9/2018.
29?
9.
18.
2018, and final sanction is granted by the Heritage Committee, my lord, on 15/6/2021. This is, my lord, for the Weavers Gallery. Now,
Page 82.
of the SFC.
It's constructed.
It is constructed. And there is their own statement that it is constructed.
It doesn't make refugees.
Lord, at page 237.
Page 82, 83, Mr. Nape answer.
Yes.
The lordship will find the.
Which kind of sign?
Lord, I have filed all construction with my counter, which is with IA. I have filed all sanctions, my lord, to my IA, which is 48858 of 2024. And my lord, these are admitted positions. The High Court says that all constructions are sanctioned. You have not questioned it. I take your lordship to that part of the.
48?
Yes, sir. 48858 of 2020.
What pages? On the lines of
And-
2015.
Yeah, please. Volume 5.
Who's checked that? It seems to be sometime after 22 in any case, because we have the documents which are on record, including the reply that's been filed by Nagpur Improvement Trust.
That's respondent number 3.
Respondent 3 saying that the sanction was granted in June 22. So I'll just confirm again because there are different.
Let us see, Mr. Mishra says that he has placed on record the sanctions in IA.
Yes. Which IA is it?
Volume 160, 167. No?
Page 59 what we document and sign.
एक मिनट madam. 167. It is 1810, not with my IA.
Seven.
167. 1810.
Yes. Eighteen 10 2019.
Yes, ma'am. It was 69 sanction.
Yes.
Then my lord 354.
Page?
354. Heritage Committee. 354 बोल रहे हैं. 354. Annexes 27. That is parking plaza approval.
Parking plaza is, I think, on the garden side, Telankari garden side.
Yes. And my lord, there is no contention or objection that sanctions are not granted. The argument is that those constructions are prohibited. If your lordship sees, my lord, the interim order which is passed by in detail by the Honorable High Court, which my learned friend referred to at page 303, 305 onwards, my lord, the Honorable High Court deals with everything. And then in the impugn order, my lord, the High Court says that if there are violation noticed at any point of time, the petitioner or any public spirited person can approach the High Court. High Court is ready to monitor it, my lord. And my lord, the High Court specifically says in paragraph 12 of the impugn judgment, my lord, that there is no challenge to any of the sanctions which are granted. And my lord, the construction which my learned colleague pointed out from my reply at page para 13 in my counter, that something of permanent nature has been dumped for constructing a banyan tree. My lord, that also there is a report from VNIT that all these structures, that all these structures are temporary in nature. There is a report, my lord. That report
7/6 of 2020. I am interim
Yes,
I 4.076.
and that report, my lord, is filed in IA 45076 of 2025 at page 9 and page 11, my lord. There is a specific report that all these constructions are temporary.
IA number?
IA number 45076 of 2025.
Page 9. Sir.
This is in respect, my lord. Page 11, your lordship may see.
Page 9.
Page 9 and page 11. This was what was argued by my learned colleague, that this is a permanent construction which has been made within the lake. Page 9, my lord, and that has been reiterated, my lord, by the VNIT. Where it, my lord? Second paragraph further certified that the said banyan tree structure is made of mild steel and stainless steel reflected by members with bolted connections. It is purely temporary in nature and can be dismantled at any point of time if required, including the foundation of structure. No access for public other than maintenance work is provided around the structure in view of the safety. Now, my lord, page 11. This is a VNIT report. They have referred to this letter also, my lord, as a reference.
No, but then Mr. Gopal Shankar referred to some dumping of the concrete blocks, 450.
No, my lord, there is nothing. My lord, from last more than 1 year, the activities have come to a grinding halt, my lord. Everything.
He said that under.
No. There is nothing which is dumped, my lord, according to my instructions.
R4 counter affidavit. It's an R4's counter affidavit, their admission.
Therefore, para 13, I am referring to this. Para 13, your lordship refers to my reply that there is something dumb. That structure is temporary in nature. That is what the report.
No, this only refers to the banyan tree structure. It is temporary.
Only, my lord, he has objection for banyan tree. Para 13, lordship.
Let us see your counter.
Yes. First para 9 and para 10, lord, then para 13. Page 15 first, my lord, my counter.
Page
15, para 9, my lord. Not para 8. 9, my lord. It is further pertinent to mention here that the apprehension raised by the petitioner is totally misconceived and no permanent structure has been constructed by the answering respondent in Landlord-tenant. It is reiterated that the answering respondent hearing merely in executing each of the plans that have been duly sanctioned by the competent authority. Not only this, various activities have also been undertaken to restore the presence of Kotala Lake at the instance of Heritage Committee. As such, even delimited heritage wall has been restored. It is submitted that the answering respondent has been scrupulously obeying the direction issued by the Honorable High Court by order dated so and so. That the construction of fountain and the other ancillary activity is installed on the floating structure. It is submitted that the artificial banyan tree is to be used for 3D projection and is stationary at one location due to the weight of structures and preset cape stones placed inside the structure to prevent lateral movement and to counter wind load, as the displacement of the structure will project destroyed image. However, the same is neither fixed on the ground nor secured with permanent foundation. The said structure by no stretch of imagination can be termed as permanent structure. The work on the site structure is being executed as per the drawings vetted by the Visvesvaraya National Institute of Technology, Nagpur. The petitioner has miserably failed to point out any lapse on the part of answering respondent. Now, my lord, the paragraph 12, that the petitioner herein has filed PIL before the Honorable High Court on completely flimsy and non-existing grounds. Now, my lord, lordship may turn to para 13, which my learned colleague referred to. That a temporary structure, that is an artificial banyan tree screen or projection of 3D visual, shall be submerged to the extent of 3 meters during summer period, and it is expected to be submerged to the extent of 6 meters in the highest monsoon. The total height of the structure is 15 meters. The weight of the substructure is 28 metric tons, and the superstructure will be weighing 30 metric tons. However, in order to keep the structure stable, recast crab stones, each weighing 46.5 kg, in total weighing 350 metric tons, have been placed within the substructure, thus totaling the weight of the structure to 408 metric tons only. Submitted a petitioner claim of foundation structure inside the Futara lake being dumped with the 7,000 tons concrete stone is false and highly exaggerated. They said that there are 7,000. My lord, all these are. Then, my lord, it is submitted that the structure is in no manner would affect the temperature and biodiversity under the water. Further, they said artificial banyan tree screen is to be used for 3D projection. The said structure is temporary in nature. Even so, it needs to be stationary at one location with the support of weight of substructure and precast crab stones placed inside. The structure, in order to prevent lateral movement and also to counter the wind load, as the displacement of structure will project to.
These third stones will be placed in that steel structure.
Yes, my lord.
Not in the lake.
Oh, no. Therefore, my lord, they report that it is a temporary structure. It can be removed at any point of time, including the foundation can be removed, my lord. It is not, my lord, dumps like this.
It's on the road.
No, my lord, nothing.
On VS Gallery, it's next to that.
No, it's not on road.
Avoiding the road.
Abit. Yes.
After that,
yes. And that is sanctioned, my lord, as per the DCR. It is not within the prohibited zone. And they have not questioned it, my lord. And now in this background, lordship may turn to para 13 of the impugnment. Page 13, para 12, then 13. Page 12, para 12, page 30. It is not in dispute that the activities of construction of Weavers Gallery and Parking Plaza are preceded by various requisite permission and sanctions by the concerned authority. The documents on record indicating the same supported by affidavit of the concerned authority have not been specifically challenged by the petitioner. In fact, therefore, the sanction granted, including the sanction dated 18/10/2019 and 1/9/2022, continues to operate. Similarly, the permission granted by the Heritage Committee on 30/6/2022 as well as 6/2/2023, granted by the Urban Development Department permitting change of user, continues to operate. In absence of any challenge to the same, a total prohibition on such activity as sought by the petitioner cannot be imposed. At the same time, it would be necessary to ensure that in accordance with the spirit of the Rule 2017, no permanent construction would be undertaken at the man-made water body Futara Lake. Thus, by applying the public trust doctrine as well as the pecuniary principle, it is directed that the respondent shall ensure that the spirit behind the Rule 2017 and especially Rule 246 thereof is not violated by undertaking any construction of permanent nature within Futara Lake. The respondent number 4, MMRCL, along with the respondent number 3, Nagpur Municipal Corporation, are directed to ensure that the activities undertaken by them do not result in causing any damage to the lake. They shall also ensure that the water body where the floating banquet hall, floating restaurant, as well as the artificial banyan tree are proposed is kept clean and is properly maintained by taking all necessary precautions, steps in this regard. In addition, the statement made in affidavit dated 25/8/2023, filed on behalf of MMRCL that have been reproduced herein before would also be binding on the said respondent. It is expected that the respondent would also be alive to the need of preserving the man-made water body, Futara Lake, to enable the future generation also to able to witness the lake in its present form. It would therefore be necessary for the respective respondent to ensure that their activities do not result in causing any ecological damage to the water body, and thus quality of aqua life is not adversely affected, though the present proceedings are being disposed of with a hope that the respondent would abide by the exception referred to herein above. It is made clear that it would be open for any public spirited person to bring to the notice of the court any act that could result in causing damage to the water body in future. Now, the High Court is monitoring it.
Not monitoring it, gives permission to.
In fact, anybody can approach, my lord. So there can't be anything which can be hidden, my lord. And with due respect, my lord, I'll say with all humility that the construction which is done is in any way is not prohibited, and it is not done, my lord. It is a temporary structure.
What about that floating banquet hall and floating restaurant?
They are on floating fountain, my lord. They are floating fountain. Lord, actually, that is constructed by NIT, but that is also has been dealt with by the Honorable High Court.
No, from somewhere we saw the proposal also considered.
It's only floating.
Floating banquet hall and floating restaurant.
No, my lord, I don't think that it is bank. My lord, floating restaurant and banquet.
Yes.
And my lord, there is also a report of IIT saying that these are also temporary structures. Page 306. My lord, everything is supported by an authority, which is not questioned, my lord.
Yes, Mr. After you got to say.
Yeah.
First, consider the delay aspect. If your lordship turn to
You are appealing for the corporation.
I am appearing for corporation, not provision. So kindly turn to page 82 of the SLP book, paper book. The last but one para. For the purpose of development work of musical fountain, sound light and major multimedia show at so-and-so, later date so-and-so by superintending engineer. Then come to the next para. Said work had been principally approved by the Heritage Conservation Committee in its meeting on 9th of December 2016. Now, sir, kindly see the composition of this committee that your lordship will find at page 71. And surprisingly, petitioners have not implemented Heritage Committee as party respondent. Kindly see the members. First, Mr. Patekar, retired IAS, retired chairman, NIT Nagpur. Then Deputy Commissioner of Municipal Corporation. Third, Patekar, structural engineer. Then Habib Khan, architect. Then next person is Principal LAD College, Nagpur. Then curator, Nagpur. Then Niri. All persons who have the requisite expertise in the matter. Now,
I, as a municipal corporation, can act only on the basis of advice of the experts. So in the meeting of 15th of June 2021, the permission was granted by the Heritage Committee, and it's a statutory committee. And that your lordship will find relevant portion. It starts at page 79 and goes on to page 83. 79 bottom, subject number 4. Page 79 of the SLP paper book. And then your lordship will come to that subject, the relevant portion, page 81. The condition, while executing the proposed works, by exercising the care that there should be no damage to the tank heritage site development work should be executed. While executing the proposed work, the security of the heritage site would be the responsibility of the proponent. That is response number 4. So that is as far as first permission is concerned. Then your lordship will come to page 89 in the same meeting. Item number 10. The general manager at the bottom of that page 89. The general manager so-and-so Maharashtra Metropolitan Corporation has submitted the map for the proposed construction of the parking plaza so-and-so, and then the relevant portion your lordship will come. Then discussion took place. Then they referred to the NOCs from concerned authorities, and they finally, on page 94, after taking the decision, approved the explicit. So the permission is granted. This is on 15th of June 2021. The writ petition is filed in January 23. And if your lordships look at page 237 of the SLP paper book, see their own averments, how the petition suffers from delay and laches. Somewhere in the middle, your lordship will find the copy of the photographs of viewers' gallery on the bank of so-and-so text, as well as musical fountain installed into the water body. Then they say that petitioners submit that the work relating to viewers' gallery as well as musical fountain is complete, and the trials are complete.
I beg your pardon, Manoj.
You wait till the completion of the work. If you are a diligent citizen, you should have immediately approached the court.
From August 22, the trials were going on. The petition is filed in January 23.
I can give you some.
This is the averment in your own petition.
We filed a petition in December 22. Then we had some amendments to make, and we again filed in January 23.
No, but the work was complete in August 22.
Correct.
Then you file a petition in December 22.
Different pieces of work were being done.
No. Your own the copy of the photographs of the viewers' gallery and the musical function installed.
Yes.
Into the water body.
Yes. We had filed RTI information asking for the plans also, and we didn't have the plans, so we didn't know what was being done.
If the work was going on,
yes,
as a diligent citizen, you should have approached immediately.
No, perhaps we could have been quicker in approaching the court. That your lordships are right. Perhaps we could have been quicker. But once my friend finishes, I just want to respond on the facts.
The judgment and order.
No, I'm sorry. May I respond? I just want two submissions. One.
Firstly, the archives show that it is a tank constructed for drinking water and irrigation. So by that definition itself,
in 1799.
Maybe. But initially now whether it is used for drinking or not, it's a different matter. But it is used for irrigation. It is used for irrigating the garden, which is just after the dam.
No, yes,
the garden.
But as far as the wetland rule application is concerned, that's been decided that it applies
to
this lake.
You see the definition. The court cannot decide.
Yes.
Come to G. And the constitution law is not of a permanent nature. The expert, IIT expert says that.
That I'll explain why it is. On both points, let me just respond first on this permanent nature. Page 14. Open it and give it to me.
Where is the report of IIT?
Let me just read what has been stated by them, my lords, in their counter affidavit. Respondent 4.
There is a reference to the
IIT report.
Page 306, the interim order which the High Court passed. We'll just locate the actual report.
No, can
I
I just read what their actual statement, their own statement is about that construction? Your Lordship needs to see this a little carefully, my lords. Page 18.
The VNIT, which is an expert body,
yes,
says that it's a deputy. So those the concrete block,
yes,
they are put in the steel structure so that it remains stationary and it doesn't.
Correct. So what happens is this: the steel structure is 30 metric tons. The superstructure is 30 metric tons. It's massive. It's about 100 meters, 50 meters long.
Yeah.
To weigh that down, they put 7,500 concrete blocks, each weighing 46.5 kilos. The total weighing 350,000 kilos. Has weighed it down and taken it down to the tank bed. If my friend is saying that this structure is not on the tank bed, let him say so. Because the only way.
IIT says that it can be removed.
No, it's not a question of can be removed. It's a question of what impact that 350,000 kilos has on the tank bed. Once you put it down and it's weighed down on the tank bed, this massive structure, they themselves say the said structure is temporary. Even so, it needs to be stationary at one location with the support of the weight of the substructure and precast curb stones placed inside the substructure in order to prevent lateral movement and to counter wind load. So the entire thing is on the tank bed. My friend keeps saying it's not on the tank bed because they're trying to draw distance.
Firstly, you deal with how do you overcome the definition?
I'll go back to that. The wetland definition, whether natural, artificial, area of marsh, fen, etc., 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 but does not include river channels, paddy fields, human-made water bodies, tanks, specifically constructed for drinking water purposes, and structures specifically constructed for aquaculture, etc., etc., and irrigation.
So the archives show that it is constructed for drinking water.
Yes.
And for irrigation purposes.
This would have been true of all man-made tank beds over 400-500 years. The question is today, when the rules are made in 2010 and continued in 2017, whether it is being used for those purposes. If they're being used for those purposes as of 2010, then it would not be a wetland. But if it's not being used, and admittedly it's not, in both 2010 and 2007.
It is being used for irrigation purposes. How?
No, they put the wall and the construction. Irrigation is not being done from there.
Is it not used for irrigation purpose in the Telunkadi garden?
Today also it is being used.
It is nobody's case. It was not their case in the High Court to exclude it from wetland on this ground that your lordships are putting. Was not their ground in the High Court. It's not been their ground here. Nowhere have they ever said that because it's irrigation, it doesn't count. They just say it's not a notified wetland, therefore, and it's man-made, therefore it can't be a wetland. These are the two arguments. Both arguments the High Court accept. Both arguments are in the teeth of your lordship's judgment in the other matter, saying that, look, these are the list of wetlands. Once they've been identified as wetlands, unless you can show exceptionally some reason, otherwise the impact of this would be massive, Manoj, which wetlands which existed 200 years ago.
The High Court ought to have thrown out only on the ground of delay and like this. You go on huge public money to be invested, the construction going on, and after everything is complete, then you apply the court.
That's why we had moved interim orders for construction not to be completed because it was not completed.
It is you yourself, see your own petition at 237.
Yes, Manoj.
And that's your own averment.
No, because there are multiple aspects of this project, Manoj. If I can just.
No, you say that even that floating this fountain is also there.
It became functional units.
Functional also.
And during G20, it was showcased.
7th February 21 is the Heritage Authority's clearance for a viewers gallery sound light fountain That's on 7th July 2021. 1st September 22 is the parking plaza. Now, these are two different sets of permissions which are given, and thereafter I'm presuming the construction started. I don't know the dates on which the construction started, because the permissions are 7.
When is the annexure
7.
annexure to the petition?
August 2022.
August 22, there is no amendment.
No, to the writ petition.
What
What is the annexure?
237.
Just check from the petition.
That is it.
So the main point is that I have acted on the basis of the permission granted by the Heritage Committee.
Photos
And they don't include Heritage Committee at all.
Where are the photos, guys? Show. You're sitting there, I'm asking you to show the photos. This is
267.
just IA 35627, Malats. Page 8 onwards of IA 35627.
367.
And the reason given by you for delay is that in the year 2021 there was a COVID pandemic, and hence you could not approve the court.
It's in public interest eventually, Malats. If your lordships feels that there was a delay in coming, then there's nothing I can say, Malats.
No, not only on delay.
No, but I mean, there are a few cases where, some bodies will move if they feel that there is some violation, Malats. I would submit that on the merits of the case, your lordship may consider it. The photos are at page 8. Page 9, 10, that's a structure. Now this is the structure that is, I'm sorry. If you see page 9, 10, you see the structure, Mala. That is a structure that is weighed down by this 350,000 kilos to keep it in one place and not move it. Those are the steel pipes which are about 45 tons, which you see all around it. That's at pages 9, 10. And then page 22, if you see for a minute, this is where we got our figures. And these are the same figures that they have put in their affidavit, page 22.
Everything is complete. Here also you see the photographs.
If your lordships are referring to page 9, 10, that is the one that they claim is a permanent temporary structure.
Yeah.
And the word permanent, the legal meaning is as against temporary, which is circumscribed by time. This is something that they have to answer, that if it is temporary, till when is this going to be up? It can't be that you put 350,000 kilograms on the tank bed and say it's temporary because I can remove it whenever I want. That is true of any structure. You can remove it whenever you want. That doesn't make the distinction between permanent and temporary. Permanent and temporary is with reference to time. So if you put a floating platform of some sort, if you put anything else which is there for a short period for any purpose, that is different. If you put a barge at the time of a kite festival, that is temporary. You'll remove it in a week. This, a fountain and the rest of it. Okay. This is from Black's Law Dictionary. I'm just reading the word temporary. That which is to last for a limited time only, as distinguished from that which is perpetual or indefinite in its duration. This is clearly indefinite in its duration. So if it is indefinite, then it is permanent. Unless, my friends, show your lordships that it is for a limited period. Now this is on the merits of it, brother. I'm only on the merits of it. Because this interpretation that your lordships place on the wetlands rules will go far. Whether it's for this wetland or for any other. If it is permitted to submit that we will keep putting structures and tank beds which can be removed whenever we want, and that is the definition of it being temporary, it's my submission that that is not correct. Temporary versus permanent is based on time. And in none of the affidavits is there a whisper about when these structures will be removed. If it will not be removed and it's indefinite, then it's permanent. In which case it falls foul of the rules, my lords. Separately, I just wanted to point out
So if you just take a look at three things, just last things are enough. First concept of the realizing. No, that's completely.
one last point, my lords, is this, that the wetlands rules says clearly
What is this connection? It's about
I'm just handing.
Yeah. Where is the black segment of the
Ramnatha Iyer also has a definition of temporary. Again, make it clear that it's as far as time is concerned. Also, with reference to permanent and temporary, my delay in coming to court shouldn't impact that if, as they say, it is temporary. If it is temporary, they'll remove it. They will give you a lordships a time when they will remove it. That's all. The second aspect is with reference to that 50 meters of the high tide level during the monsoons, and this is what I think the applicant has also said in their application where they have to repair the cables. They say they filed in March and they asked your lordships that allow us to repair the cables in March because summer is when we can change, alter it. Monsoons, it will be difficult. So during the monsoons is when you have that high tide level. So 50 meters from that high tide level has to be honored. The construction that they are carrying out is well within that 50 meter.
Which construction?
The construction that they're carrying out of the or the ones I showed the photos, that wall that has been constructed, etc. The photos I handed up, that is well within that 50 meter radius. It's right along the border of it. So eventually,
maybe that sewage problem has been created because of the interim order passed by this court. And they constructed the wall, the sewage which flows from the slum areas, just above that.
That's anyway flowing. That cleaning is a separate issue. It's before the NGT. They have taken suo notice of it. They are dealing with that issue of the sewage which is going into that lake. That lake is full of sewage. There's no question about it. We have reports which we have placed showing the high level of bacteria and other infectious objects which is in that lake. So that's a separate issue. I don't want to trouble your lordships with that. I'm limiting myself to these 2 points, Manoj. One is permanent temporary, the other is 50 meters. I'm grateful. Item 4.
What's going on?
Wait.
Like.
You are in which application? State?
This ninth this one. I'm for the petitioner here.
Okay.
Yes,
I have prepared an amicus note which was circulated, but if it hasn't reached my lords, I have copies here. There are 9 applications today, so I thought I would summarize them for your lordships. Since this matter is coming up really for the first time before this bench, can I, within 2 or 3 minutes, summarize this whole Prakash Singh matter, and then these applications will fall into context. The main judgment of 2006 gave 7 directions in the interest of administration of justice. State Security Commission, National Security Commission, separation of investigation from law and order, etc. The matter with which we are concerned today, is about appointment of Director General of Police. And the main direction, the main Prakash Singh judgment of 2006 was that there must be a fixed tenure of 2 years for state DJPs who will be selected by a panel prepared by the UPSC after the state sends names. Then in 2019, there was a refinement of that direction because your lordships are also specified a minimum of 2 years tenure for a DGP in the main judgment. Now, officers who are very close to retirement were also being suggested. So therefore, in 2019, your lordships said there must be a residual 6 months tenure. Now, in spite of that, problems arise from time to time in the states, either because states don't send names in time or UPSC sometimes doesn't send back names. Then states appoint ad hoc DGPs, etc. So that is the problem your lordships are faced with from time to time when the bench assembles applications with regard to one state or the other. Now today, there are 9 applications. I'll quickly summarize each one of them, and your lordship may decide what your lordships want to take up straight away, what is urgent and what can wait. There is also an amicus application which I have moved in 2020, which is still pending, which I would request your lordships to take up at least at the next hearing as to how this court should now, in my respectful submission, manage this matter. Should every DGP appointment be coming up to this honorable court, or should this court now confine itself to examining the constitutional validity of police acts which have been passed after the Prakash Singh judgment, whether they are in conformity with the judgment or not? I have suggested in my application that individual cases now should be monitored by the High Court. As far as the states are concerned, the state can appoint, every High Court can appoint its amicus and monitor the implementation on the ground, including separation of law and order from investigation, etc. Out of the 9 applications today, perhaps the matter of urgency, one is from Tamil Nadu, where one particular officer has asked for consideration. He falls within less than 6 months. But he had faced criminal charges and disciplinary proceedings, all of which have gone.
he has been exonerated, but he couldn't be considered on 2 previous occasions, Millards. So whether your lordship should make a one-time exception in his case, Millards, that may be of the greatest urgency. Today, Mr. Naidu is appearing. If he moves his application, then I can respond to that, Millards. And then, Millards, Mr. Prakash Singh has moved applications suggesting, in the light of, because 19 years have gone by, Millards, since the main judgment, Millards, this UPSC suggestion may need to be rethought, Millards. And what Mr. Prakash Singh has suggested in his application, which I as amicus would support, is a change in the system by which now at the state level, it should be the Chief Minister of the state, the Leader of the Opposition, and the Chief Justice on the pattern of the CBI, Millards, which was initially suggested by this court in Vineet Narayan and then came through by legislation. That may be a major tweaking which may be required in the light of 19 years experience, Millards. Broadly, that's the picture, Millards. So applications, Millards, if the petitioners wish to move their applications, Millards, in order of urgency, they may, Millards. And there is contempt, Millards, as far as Jharkhand is concerned, because Jharkhand, Millards, has given a go-by entirely to this consultation with UPSC, framed its own rules, then appointed an acting director general who continues. Now, Millards, those rules are clearly contrary to the Prakash Singh judgment, Millards, because the state has framed its own rules where they have sought to include a UPSC member. But the UPSC has refused to participate in the Jharkhand committee, saying this will be contrary to the Supreme Court judgment. So those Jharkhand applications are also before your lordships.
There is a deviation, I would think my learned friend is right.
My lords, permit me.
Yes.
The first one, Millards, I think, for Pramod Kumar, the Tamil Nadu police officer. My lords, kindly take it up because there is an urgency in this matter.
Given we can go with the note of the. Oh, yeah, but have I given up the note? No. My note was here. I had not handed up.
I have the note.
Your lordship got. This would be
at page number. Yes, at page number 7 of the learned amicus note, Millards, my case has been put. Page 7 of that.
Yes.
Millards, I belong to 1989 batch. Millards, in 2009, under my jurisdiction, a crime took place of huge proportion. A particular company had floated schemes, collected money left, right, center, amounting to thousands of crores. A crime was registered. When that was going on, Millards, when that was going on, one of the accused directors registered a crime saying that the police have threatened her for money. Then, based on that, a crime was registered. Then 2 crimes. The depositors, running into thousands, have stated that the investigation vis-a-vis their deposits and cheating should be transferred to CBI. The Honorable High Court of Madras not only transferred that, but also the other one. Eventually, since I was arrested by CBI, I was made accused by the CBI and not by anybody else. Then, Millards, eventually they filed final report saying that it's a mistake of fact. Then, Millards, I got discharged and that's become final. When it comes to disciplinary proceedings, they were quashed. All this has taken time until 2022. I would have been eligible in 2020 itself. I was passed up. I would have been eligible in 2023. My junior became the Director General of Police, and he too about to remit the office. Now, Millards, in that context, I have applied because I am to retire by next month, 30th. I would have had the longest tenure as a DGP. But for this case, which has come to a knot now. Now, Millards, in that context, it is quite essential because it's not fault of mine.
You are retiring next month.
Yes, Millards, September 30th.
And when is the present incumbent retiring?
14th of August.
14th August. It should be 30th.
Already gone, but it will be 30th of August.
30th August, the incumbent. And I was asked to provide the details. I did provide, but so far my name has not been included because of Prakash Singh's directive that there should be 6 months. My lords, my girl, appreciate, I would have been a DGP in 2020, or at least in 2023. I am the senior most for the last 4 or 5 years in the state. And now with a clean sheet, nothing surviving either on the departmental side or on the criminal side.
Who is appearing for state of Tamil Nadu?
Well, it's earlier my lords indicated to them, rather given notice and said that you enter your appearance. So far they don't. Tamil Nadu, state of Tamil.
We'll request 1 week for filing Wakalat.
Millets, by then the bell tolls for me. By then, millets, nothing would survive unless the name has been included and it's been sent to UPSC and they consider. It's been extremely on a thin line of time. Page 24. Choose a page.
The election comes to the as late as
Let's September 30th.
You get your by Friday. You get your instructions by Friday. You can on Friday.
Essentially, millets, it's an issue my loss. May have to decide state
But then
government has
that-
nothing to do with that.
Then you will have to be heard.
Right. Great.
There is one IA on behalf of Mr. Prakash Singh, which the amicus had mentioned regarding changing the method of appointing the DGPs, because what has been happening is this existing direction that the UPSC recommends 3 names and then the state government chooses has been leading to a situation where repeatedly various state governments have been appointing acting DGPs despite an order of this court saying that acting DGPs will not be appointed. We have suggested, my lord, that order needs to be tweaked and the pattern should be the same as the appointment of Director CBI, meaning.
And the learned amicus also supports.
Yes. So therefore, that application.
You had given me, is it?
To support what Mr. Bhushan says, more recently in Anup Baranwal, that Constitution bench on the Election Commission, there also your lordships have sustained 5 judges. That manner of appointment, that 3 similar format.
Subsequently, the legislation does not provide that.
Legislation has, in our view, that challenge is still pending, Maloj. It hasn't removed the basis, but the Constitution bench stands. The fact that, in fact, Justice Rastogi's concurring judgment puts a table showing all the various authorities where we have such a similar system like in the CBI, where there is independence. The idea is to insulate the police from political interference.
And here it is by the direction of this court, so only that needs to be slightly tweaked in the light of subsequent experience in the last 19 years.
Maloj, item number 9.
All those issues will have to be considered, but they can't be considered,
If you see page 8 of the note, page 8 of the amicus's note, there is a list of the various acting DGPs of 7 states. And all of this is a violation of your lordship's orders repeatedly. You can't have acting DGPs. You've repeatedly frowned on it, 3 judgments on that, and still they persist. So the learned amicus's suggestion is at page 10, Maloj.
Go ahead, go ahead.
No, that's what I just wanted to, I just wanted to.
After minute,
After the conclusion meeting is over.
of the constitution.
Okay, mine is concerned if you look, the counter has been filed.
What is your matter about?
My item is 4.2. It is with respect to Jharkhand DGP, my lord. Now, the chief secretary has filed, my lord, his reply. And there is evidently, my lord, a contempt. In the sense, my lord, that they have appointed an ad hoc DGP, which was not provided for in the Prakash Singh matter. And one of the senior most persons who had been appointed as DGP, he was removed, he was transferred, even though, my lord, there was no justification for his removal. And this is within the 2 years tenure. And this was done specifically so as to accommodate Mr. Anurag Gupta, the present incumbent, so that he would avail of the 6 months retirement. The date of calculation went back to the 6 month period, and therefore, my lord, he could gain a benefit from it. And the secretary and all, they do not respond to this, and instead they say, my lord, that we have formulated rules, which again, my lord, in clear violation of the Prakash Singh judgment. And now his appointment.
What are the rules in the Jharkhand?
Yes, my lord. If your lordship will kindly see, we were next it. P8.
Milord, that page 6 of my note, Milord, I've summarized what the Jharkhand selection procedure is, Milord. Page 6, para 3.
Under the copies.
The committee which was supposed to have been formed, below, that's absolutely in violation of the Prakash Singh judgment.
Just a matter of fact, they filed a petition in the High Court challenging the constitutional validity of these rules. That is pending in the High Court. You can decide which way you want to go. I have no problem, but they can't sort of challenge it there pending there.
Have retired on 30th of April. He has not been given extension by the central government. This particular officer, Mr. Gupta, would have retired on 30th April. He has not been given an extension. And in the guise of these rules, which came in the month of January, after him having continued as an acting DGP since July 2024, so that now first he continues for 8-9 months as acting DGP, then the rules are framed, then he's made the DGP as per those rules so that he gets a fresh 2-year terms as a DGP. Otherwise, the person was not fit, his name was not sent over there to the UPSC panel. And that is exactly why the UPSC panel was not involved.
In fact, at one point in time, the Election Commission had removed him.
And as of now, he is not in service. Legally, he is not in service, but he continues as a DGP, Milords. Because central government has clearly stated on 22nd of April that your service term ends on 30th of April. Despite that, the state government has chosen to keep him as a DGP.
And the state has given him extension, Milord.
And not the state government gave an extension to all India service officer, Milords. That's what they have done. It's a case of gross illegality, Milords.
Who are you?
Milords 4.1. I'm the petitioner in 4.1, Milords.
But you are also in that matter.
Yeah, that's 4.2, Milords. It's the same. Almost it'll end up being the same.
You are the contempt petitioner.
Yes.
Mine is also contempt.
His is also contempt.
It's okay, sir.
Has to be heard. But if somebody has already filed a writ petition challenging the virus of the rule.
So let's see, I'm not filed it.
Same person.
Only the
He is the same person who was filed in the High Court, Milords.
Milords, now that this has been brought to the court's notice, Milords.
Not disclose this fact.
Now that this has been brought to the notice of the court that those rules have been challenged, as amicus, I would suggest, Milords, that just as the validity of certain police acts has been challenged before this court as not being in conformity with the Prakash Singh judgment, I, as amicus, will move an application for transfer of that challenge to this honorable court, because ultimately it's a question of compliance with the Prakash Singh judgment. So, my lords, I make a statement today that I will move an application for transfer of that challenge here.
We'll argue that here, no issue.
All the states are doing it. Even UP has done it. That's what they were next, Millard. So one state after the other, Millard, they're trying to bypass the.
Seven states. I have a chart here.
Milords, there's another aspect which will be relevant over here, Milords. Milords, in the order itself had
Another
stated.
question would be, right from Vishaka, whenever we exercise our extra powers of legislature, they have to be in place only till a competent legislature enacts a legislature. Like in the election commission case, whatever it be, the constitution bench found that the composition has to be such and such. The parliament enacted a law which is not in conformity with. So in such case, what would prevail? Whether the directions of the.
It depends, my lords, it depends.
Exactly the same situation had arisen. This court directed that candidates will have to declare their assets and their criminal antecedents. A law was brought to overturn that. This court struck down that law, holding that this is in violation. Our directions were to effectuate fundamental rights of citizens. And therefore, this act violates those fundamental rights. Same situation applies this kind of case also. The directions in Prakash Singh were to effectuate rights of citizens under Article 21.
That's right.
That's the basis of that.
Constitutional interpretation.
It says that we need to free the police from the strangulating control of the political executive in order to effectuate Article 21 rights. And that is why those slew of directions were given. Now, my lord, if an act is brought to overturn those directions and say, no, DGP will be appointed and will remain at the sufferance of the government, the court specifically said DGP will have a fixed tenure of 2 years.
Yeah, please. Yes,
Same
Mr. Prakash Singh.
My lords, and Honorable Court was aware about this. My lords, there's only one thing which I would like to add. My lords, Honorable Court was aware about this and in the order dated 3/7/2018 had specifically stated.
Yes, I will. Say that. Sorry,
yes.
3 judges, but that's why it's always come before 3 judges before this honorable Supreme Court.
All modifications earlier have also been made by 3 judges.
I had considered that in Sanjay Mishra, Director of ED.
Lordship.
Yes. Yes. Director.
Yeah. Yeah. Bully.
Right. Clear for it.
But we heard of every.
Actually, Mr. Prakash Singh is here, but he's the father of this litigation. But he wished to say, Mr. Prakash Singh wished to say something.
Yes.
Thank you, my lord, for giving me this time. So I just want to bring to your notice that the Supreme Court used to monitor regularly the implementation of its directions. Somehow, for reasons which I can't explain and which I don't know, for the last 6 years, that has not happened. The main petition, PIL, the main police reform petition has gone into deep freeze and there is no monitoring. A lot of these problems which are coming up before the Supreme Court are essentially because that monitoring has stopped.
That is why, my lords, this application as to how monitoring is to be done, my lords, if on the next occasion, this application 59862 of 20, moved by amicus, my lords, is taken up. We'll suggest a way forward by which implementation is monitored regularly.
In fact, my humble suggestion, my lord, is that because monitoring is a very complicated business and that monitoring witnesses a lot of heat.
No, but then do we possess the expertise to monitor all these issues?
No, but so implementation of things like setting up a state security commission, police complaints authority. These are all only matters of implementation of directions. These don't require expertise.
Police complaints authorities are, I think, in place in most of the states.
In some not, Millers. So that kind of implementation is supervised, Millers, practically only by high courts. So the suggestion made in this application is that the high courts be requested to have dedicated benches which may assemble once in 3 months or whatever, have their amicus and see that the judgment is given effect towards. That's all. No, we tried it now. 59862 is the application notes of 2020. If that can also be taken up at the next hearing minutes. The Lordship can have
Take these applications after the CV.
Lordship, please.
What about contempt? If you have already filed a substantive petition, let that be. Why should you pursue the complaint?
Well, my lords, there's one aspect onto this. If my lords would see the order dated 3/7/2018, I would read out in para 6.7 and
these contempt petitions appear to have been filed by the political rivals.
my lords, I'm not the political rival, my lords.
We have been saying.
The general people are concerned
No, no.
with what is happening.
No, a person who is aggrieved can very well expose his cause. A person who has been superseded or whose claim is being denied, why should we permit our...
Your Lordship, we consider one thing, my lord, that the matter is pending before this court, my lord, where the contempt of the order is concerned, my lord.
We'll consider the amicus application with regard to the transfer of the proceedings about challenge. Correct. We are not inclined to enter in the within contempt petition. The learned amicus states that he would move an application for withdrawal of the petitions from the High Court with regard to challenge to the rules framed by the Jharkhand government and transfer the said proceedings to this court to be heard along with the other matters. When will you file such an application? When will you file the application?
But I'll file it within 3 days.
There are other states also where the legislation is there, Malad. So
That's what he's saying. So all that can be considered together.
Good legislations have already been challenged.
They are not all here.
And if there are any left, I'll find out and I'll.
Therefore, get all the states.
If it's an amicus application, on oral application.
You give the number of that.
Yes,
great.
Exactly.
On the oral application made by the learned amicus, the petition number so and so, pending before the Jharkhand High Court, shall stand withdrawn from the High Court and transferred to this court to be heard with the present branch of matter.
Tamil Nadu matter on Friday.
Tamil Nadu on Friday.
Well, that's my item 9 is a separate contempt petition. It's not on Jharkhand. It's 7 states where there is a violation. So it's not no political rivalry. Mine is different. So just pointing that.
Though contempt is for the country.
With my assisting amicus bullets, their names are shown in the cause list, it's easier when the matter comes. Otherwise, the matter gets missed if their names are not shown. But it's two.
Their names are not
shown. I've given their names, but it's not true.
Just you give the names, we'll ensure that on the next list.
The online portal also may be open for us to file anything. Otherwise, it will be difficult.
My lord, the Jharkhand contempt matter, my lord, that also may be heard along with.
No, we are not entertaining. We are always saying that we don't permit the courts to be turned into political. Certainly, you are supposed before the electorate.
Mine is different, Malad.
No, we are talking about the contempt with regard to Jharkhand. A person aggrieved can very well go to the High Court or the CAT if he is superseded. Why? Public, the PIL jurisdiction is for a person who is on a. No. So wherever the contempt petition is filed with regard to a specific challenge, will dismiss them. We don't want this contempt jurisdiction to be entertained to settle the political squares.
The point is, my lord, it is a contempt of the High Court, Supreme Court.
That will consider it. When we hear the learned amicus with regard to the challenge to the rule. Larger questions will have to be considered as to what extent the directions issued by this court and the power of the competent legislature to legislate upon the.
But now the problem will be when we go to the High Court, my lord, they will say that the contempt, the Supreme Court did not hold it as a contempt.
They withdraw it. Withdraw the contempt petition.
Withdraw with liberty, my
lord. No, we are not granting any liberty.
Otherwise, my lord, this will be the position because your lord.
A person aggrieved. The PIL jurisdiction is for someone who, on account of their socio-economic disadvantages, are not in a position to espouse their cause. We do not want this jurisdiction to be exercised for settling the.
Let us go before the state, my lord. Therefore, my lord, your lordship may just give us this much.
We will grant you liberty. If you want, we will grant you liberty to withdraw. That's all. Nothing more. A person who is being superseded or who is being entitled to be in place of that person who is on a extension. He can very well challenge. He can go before the Central Administrative Tribunal. He can go before the High Court and challenge that. Why should we involve somebody who is a political rival to raise that grievance before this court?
The point, my lord, actually police officers, they don't want to come before the court.
No, that's incorrect. That's incorrect.
Item 48 is.
That's incorrect. We are having many petitions wherein the police officers are also litigant before us.
Item 48 is also similar, Lord. Item 48 is connected with 4 similar situations, contempt for various other states, same situation. And then item 48, Lord, is also similar.
That's mine, my lord. It's mine.
There's a contempt, Lord, and so far I pay for Andhra, we complied with the policy.
That's dealt with in the amicus note as serial number 9. He says that it needs to be considered. His suggestion, my lord, that
6 months period.
yes, so all that will be subsumed in that. So that your lordships, we will assist your lordships on that.
After this.
After this.
Except Mr. Naidu's matter.
Let the state file whatever responses they want to file to Mr. Prakash Singh's application for modification of the directions regarding appointment of DGP.
Regarding appointment of?
DGP of states, we have.
He wants the constitution to be changed.
Yes. It should be that.
It should be the chief minister, the leader of opposition, and the chief justice.
Yes, that's right. So on that, my lord, whatever reply they want to file, let them file so that next time your lordship can hear the matter.
I think in all appointments, including collegium, Mr. Bhushan should be made a permanent member. Then everything will be completely in order.
Unnecessary snide remarks that the Solicitor General always likes to make. If I'm.
But then, if the Chief Justice of India or a Chief Justice of the High Court is made to sit on these committees, then would it not amount to having the very concept of separation of the powers?
It's already there, my lord.
And if the Chief Justice is a party to that selection committee, and if that is challenged before the High Court, these things also require to be considered.
That's not because we don't have another neutral authority that we can think of. It's only because of the lack of another neutral authority, Manoj, that we could have on that committee. It is not only confined to the judge. If it's somebody else, the way
say that elected people are not neutral. Right. You cannot generalizations like this.
No, it's the
I'm not appearing in this matter.
Execute
such sweeping justice.
In
agrees with the chief minister. Then the opposite.
In 4.1, my lord.
No, not at all. That's how it is right now. CBI director appointment is like that. Nobody is raising questions about it because there is an insulation. In the election commission matter, your lordships interpreted Article 324 and said it's essential to ensure that the executive doesn't have a majority on that committee. So when you bring in a law and you restore that, you're going against the constitutional interpretation that the Constitution bench has given.
It is a separate matter. Pending.
That's
why I think about a particular fact in 4.1, my lords. One, we are not a political party.
So you must also have been set up by someone else.
Yes, my lords, I'm just pointing out something which my lords would see.
My petition.
You are allowed to withdraw.
Wish you would give me the liberty, madam.
No, liberty only to withdraw. Nothing more.
On page number 6, my lords, in 4.1.
Let us see your credentials.
This is 4.1.
My lords, would kindly see page 6 of 4.1, 6.7 and 7. My lords was aware about this.
He's looking at 4.2.
4.2, oh no. My lords, it's in 4.1.
The contempt
So only the population where the majority is tribal, they only need special governance, not the other states. According to you, you are interested in promoting the welfare of tribal persons. And since Jharkhand is a state with a majority of tribal population,
Please, Manoj.
it deserves a good governance. So the other,
That's where they are working in that particular territory. That's where this NGO is working. And they are working in other fields also, Manoj. They have challenged the extension of Panchayati Raj to tribal areas. Manoj, there are only two aspects. Manoj, I understand what has fallen from Manoj, but on page 6, if Manoj would see, 6.7 and 7, Manoj was always aware about this fact that one or the other method to circumvent the orders of this honorable court would be devised by the states. And hence Manoj had said, Manoj has page number 6.
Yes.
6.7, any legislation, rules framed by any of the states or the central government running counter to the direction shall remain in abeyance to the aforesaid extent. Now, Manoj, if it has to remain in abeyance, you cannot act on to that said rules and appoint a person as a DGP. The second, Manoj, and 7 was the present direction shall be followed, whatever, by the union and the state territories of any state government has a grievance with respect.
We are not inclined to entertain the present petition. First, the present contempt petition is basically filed for disobeying the orders of this court against the Chief Justice of the against the Chief Secretary of the State of Jharkhand. Carry on. Condition of the petition that the rules framed by the state government are done only in order to protect one Sri Ajay Kumar Singh.
No,
Anurag Gupta.
Anurag Gupta is incumbent.
Sri Anurag Gupta. So, there is also the grievance that one Sri Ajay Kumar Singh was unauthorizedly removed from the post of head of the police force. It appears, presently it appears to be prompted by the dispute between the two officers of the police department, the one Ajay Kumar Singh and Gupta. If a person is aggrieved by any action of the state with regard to his illegal removal from service or from denial of his legitimate claim to a post, such an officer can very well take recourse to the remedies available to him in law. First of all, the public interest litigation is a mechanism which is devised by this court so as to dilute the issue of locus and permit a public spirited person to approach this court or the High Court on behalf of the persons who, on account of their social and economic backwardness, are not in a position to approach the Supreme, the High Court or this court. The jurisdiction cannot be permitted to settle the scores between the competing office. In that way of the matter, the contempt petition will dismiss. Yes.
Second person, the second.
Let's, on this DGP issue, just I want to mention just one fact. Police is a state subject, and whether it's there is a federal issue also involved in this, apart from the other things, which may not be involved in other matters. Because every government would want his own DGP because he is the head of the.
Well, that's what my learned brother was discussing.
Yes.
If somebody, some rioter is thrust upon a particular state, then
Law and order.
That's the point, Mullah.
And suppose the chief minister is also a home minister, then we have two
Parallel.
Two officers who do the chief minister and the and if it is the home minister. Normally, in many of the states, home department is kept by the CM.
Correct, correct.
On one hand, and the Director General of Police on the other hand.
That's right. So, there's the
These are also the issues to be taken into consideration.
That's what I'm saying.
And
Therefore, there's this solution that they have found, may actually be violating the federal structure.
And there is no reason not to trust the chief minister, whether it's Jharkhand or Rajasthan or any state. He represents the electoral will of the people.
Okay. These kind of constraints should not be put, especially when you
But
come
this
to
was a
law and
panel.
order.
What suggested was a
Well,
UPSC
anyway,
panel of state
this
cadre
will argue
officers.
that.
It's
We'll
not
argue.
outsiders who are being thrust. It's a state cadre officers.
No, but
panel
state
of names.
no, like the state cadre, there are around 4 or 5 persons, or maybe 6 persons who are in the cadre of the DGP. And at times, the government for A reason or B reason, they find that rather than A,
yes.
B is more, and even it happens in chief secretary.
Yes.
There are around 6 to 7 or maybe more, depending upon the state, the number of additional chief secretaries. They are in the same scale.
Yes.
The chief minister of a state might find that for carrying out the government, a particular person is more suitable than the other.
But the final choice.
Better coordination, etc.
Yes.
Administration.
Correct. But the final
Talking
choice
about law and
ultimately of the
order
chief
and
minister. The chief minister has to look at the panel sent by the UPSC. Final choices of the
Why
chief
should
minister.
the- why
Where is the
All these issues require consideration.
License.
3 names.
That's all right. But I mean, point is, why should the UPSC be involved at all in these matters? And Prakash Singh's case in para 29 says, subject to rules.
Would not be removable in those 2 years except in consultation with the State Security
But
Commission.
that itself is problematic.
There is a follow-up between the chief minister and the DGP. Should the entire machinery be jeopardized and the state come to a standstill?
The common man would suffer.
That is why.
No, it's law and order.
The suggestion is that UPSC should now be reviewed. That was our suggestion. That now it should not be UPSC anymore in the light of 19 years experience. So what is the alternative which your lordship?
Your lordship may
Consider
consider.
all the
Institution itself.
Let's not take your lordship's time now.
October 8 में वो करेंगे.
Next one to the law.
No individual grievances will entertain. We are making it clear.
Lordship.
Let those individuals take recourse to the remedies available to them.
Keep you obliged.
Grateful.
May I please move?
There are 2 other contempt petitions, Madam. One more.
Yes.
Diary number, Madam, is 35226. 35226. There's another contempt petition on the same lines, Madam. For Jharkhand, Madam,
There are 3 contempts.
D5226.
Fine.
Malad will give
Jharkhand.
Yeah.
Jharkhand.
We'll give them.
Same, Madam.
not the other case, alleged case of there are other cases of alleged contempt. We are in compliance. My state government is in compliance. Not would your lordship keep them on board or dispose them off as well, because these are contempts, Lord. And there is
That's item 48.
yes, sir. In item 48, sir, I am making a request, sir.
Illustrated. The lordship may
Lord,
consider.
may I just say this? Lord, I mean, I place that affidavit on record. Yet they show me as non-compliant. There was an earlier. There was an issue.
They are compliant.
Amicus says that we will consider.
Let them supply the
Let
copies.
the Mike is concerned because the note doesn't factor that in.
Yeah, let them give the compliance report. Copy of the compliance report maybe. Sir.
It's already given.
Give them the complaint.
We'll give a fresh copy.
May I please move? Minutes pending the SLP minutes, 545 students, my lords permitted them to write first year exam. Thereafter, through another order, they were asked to appear for the supplementary. Now they have moved over to the second year minutes. The same relief needs to be granted minutes because they were admitted based on the Honorable High Court's order. Later the matter traveled minutes. For that purpose, in the interregnum, and there was an act and the regulations, when neither could be enforced, this batch came up. That's why, minutes, the Honorable High Court has accepted in principle that Section 14 of the Homeopathy Act is correct, but since it was midway, the admissions, it could not be applied that academic year. We belong to that academic year, my lords. My lords may kindly see at page 19, the previous orders. Page 19, my lords, we have filed IA for directions, my lords, in that one. That's come up today for consideration. That order was dated 23rd July 2024. Page 19 minutes. My IA is minutes 158131 of 2025.
Madam, this is the case which came up.
Please, my lords.
Referring to his order, RIA was not listed that day.
Yeah.
He is referring to his order. This is RIA was not listed. Our IA was not
As
listed.
far as prayer A and B is concerned, my lords, we are not objecting because they are already protected, my lords.
That was not
As
listed.
far as the prayer C is concerned, my lords, there is no academic year is mentioned, my lords. May I just also point out
That interim order is not here. We granted the detailed interim order.
Please, Malus, but in that order, Malus, there was no IA mentioned, Malus. So there are colleges who are taking benefit of that order also, Malus. Just clarify in the today's order, Malus, just only for academic year 21-22 and 22-23, Malus. Because they are protected by your lordship's order, Malus. And in a homeopathic course, Malus.
21-22 and 22-23.
21-22, Malus.
21-22
is protected by your lordship's order, Malus. That's
not 21-22.
And 22-23 in the SLP number 7138, Malus. So they are protected. They are protected, Malus. As far as prayer C is concerned, Malus, because they have not stated the academic year.
Can you give me a copy of that order? Earlier order.
Please,
because I think this is Duria and myself.
We will pass it on.
I'll pass it on to you.
We may apologize. No, there are 2 copies only. Yeah, please give it. The third one too.
Well, if you just see, Malas, if you just see the order passed on 9/6/23, Malas, the academic year is mentioned in this order also, Malas.
Want us to clarify that it will apply only to 21-22 and 22-23.
Please, Malas.
But we'll have it on a near date so that the matter can.
Please, Malas, may I just need one more clarification, Malas? The academic year 21-22, many of the colleges they applied either to this court or before the Delhi High Court, Malas. They were protected. But there are few colleges, Malas, which they do not have any protection for the academic year 22-23, Malas. Malas, they are also getting benefit of the last order passed by lordships on.
So we say that cannot be clarified now. See, one of these days we'll hear it and finish.
Please, Malas.
That's what on CJ also said.
Gratefulness, my aim may be there.
We'll pass it on.
Great. Next.
Malas, even in their IA, Malas, we are not objecting to the prayer A and B, Malas.
That's what we.
Please, Malas. So grateful.
I mean, very fair.
Nice, Malas.
Plus, item 6, Malas, there is an IA which is listed today, Malas. The main matter is not listed, Malas. In the IA, Malas, which is filed by my learned friend, Malas, they are seeking a vacation of the stay which was granted by this court while the notice was issued, Malas. My only request is, Malas, the main matter may be taken up for hearing, Malas, after 2 weeks or so, Malas. We wish to file our joint
reply arguments to my IA, which I'm yet to open. My lord, it is not in dispute that the documents were exhibited. It is not.
Copies or originals?
Originals. I mean, originals were exhibited.
Lease deeds.
I'm sorry, my lord?
Lease deeds.
Lease deeds. So they are exhibited, no objection raised at that point. They raised objection prematurely at an earlier stage and post the marking. I have the list of
whether they raised it or not,
Was it not obligatory on the part of the court to impound it and send it for proper stamping?
But that never happened. So, my lord, today my modification, I am applying, seeking modification of this, my lord. Excluding those documents, let the trial continue. It's a suit for partition of 2008. 300 documents have been exhibited. Let him at least cross-examine me, my lord. Parties are getting old. My lord can...
Proceedings. There is a stay.
Please, Minister.
This break for vacating. We will have it, I have the main matter after finish.
All I'm saying, my lord, people are getting old. So therefore, let them cross-examine me or let the trial continue, my lord, so that my lord...
Doesn't have it after 2 weeks or so.
Mother
Any
is
fixed
there,
date?
my lord. Mother and stepmother, everybody is on either side. So all I'm saying is, let the trial continue. And rents are not being released.
We'll have it after.
Obliged.
Main matter.
Would my lord indicate a date, my lord?
Friday is in the mother.
Well, this is a matter where I'm waiting for the state, Mother. The other side, they haven't filed a reply, so you also may take it up.
I want some time to file a complaint. It is
That-
entering of orders operating against.
TASPAC matter, your lordships had dealt with.
4 weeks.
Very well.
Tamil Nadu wearing warehousing corporation.
That's right.
Interim orders operating against me.
That's all right.
Have it after November.
Whenever, my lord.
Whenever.
I never ask for a.
Otherwise, the learned solicitor would again say that I am making unwarranted comments about the.
Have I ever said that?
I am talking about the learned solicitor. I am not talking about you.
Said that. I
was telling Mr. Raju that otherwise again I will get the compliments from the learned solicitor that I am making unwarranted comments about Mr. Raju's client.
Our endeavor is to see that what is the impression about ED changes, that I'm sure I'll be able to convince. So today or tomorrow I'll be able to convince my lords. That is my confidence.
Yes, of course. We don't have any prejudice or biases against anyone. We decide the matters on the basis of the facts as they are.
I have never said anything, I always taken my sporting skills. But what the solicitor said is correct. The perception outside is, but it percolates. What my lord says percolates not only in the media, but percolates in the judiciary also, my lords. I'm sorry to say that, but it percolates. Therefore, my lords, it does.
That's why we have.
But whatever we want to say, we say through our judgments only.
Yes, my lord.
Absolutely.
But even
The
if
other
your
day
lordships were not to make the comment, the perception outside is still there, man.
No, that perception is.
It's not necessary that your lordships have to make a comment.
Through different videos. But that we
So
cannot
we-
reveal.
Yes.
In one matter, my lord,
You can also start something like that.
in one matter, my lords,
Well, can we just have it after the CV bill of the
After
Constitution?
the CBS.
Yep.
grateful, my lords.
Millets, a public sector undertaking, the respondent appoints an arbitrator.
Led by Ms. Bhati, so I'm being led by Ms. Aishwarya Bhati. What is need to be another court, your lordships may.
If your lordships will permit, I'll appear virtually, Malad.
Yes, madam.
May I submit, please? Millets, in violation of Perkins Eastman, a public sector undertaking appoints an arbitrator unilaterally. That was challenged before the Honorable High Court of Odisha. The Honorable High Court has refused to interfere. An SLP was filed before your lordships and their judgment was suspended. Then, Millets, we've intimated the learned arbitrator that the Honorable High Court, Supreme Court has been seized of the matter. Please hold your hands off that one. Now, Millets, kindly see page 9 of my IA Millets, where I've annexed my communication and the notice that's been given to me. 171973 of 2025 is my IA Millets.
Yes, madam, what is this?
Malads, your lordship may hear the matter finally, Malads.
But how can the learned arbitrator proceed when you are already stayed the order of appointing an arbitrator.
My lords, my instructions are that the arbitrator has simply requested the parties to come and explain, my lords. If you're,
May I read that sentence, please? Whereas it transpires from the above one order of the honorable.
Whereas an award is required to be passed within 1 year.
Yes, there's no specific direction to stay the arbitral proceedings, though the petitioner prayed as an, whereas the award is required to be passed.
my lords,
If
your lord,
you are inclined to grant plea clause,
Great.
substitution is allowed in terms of plea clause.
Great.
I'm the petitioner. IA is filed on Thursday, knowing that your lordship is hearing the constitution bench tomorrow, without notice to us, behind our back. This, your lordship is having advisory tomorrow.
Even, my lord, not behind your back.
No, behind, no
You don't
notice
have
is
to
given. They are all
personally come
here.
and serve you.
No notice,
Sir.
no service, nothing, but in any case, your lordship is hearing advisory. By moving this IA on Thursday, they want this to become a reference to a constitution bench on the same issue. Your lordship knows
Can
the
I, my lord,
limitation
it's
in the
my
advisory.
can I, my lord, at least make out my case?
I am saying defer it till after the judgment in that matter. That's all I am saying.
Can I, my lord, make my case? This is a petition file praying for, my lord, the reliefs. Kindly have a look at, my lord, the reliefs prayed, my lord.
So now IA not come into India.
Main petition, my lord. Kindly have a look. Page 11, my lord. Page 11. Issue a declaration that the governor's action of reserving the so-and-so bill and so-and-so bill for consideration of the precedent is unconstitutional. So governor's power under Article 200 at a stage where it has not been matured into an act, assent, etc., be declared illegal. Issue a declaration that withholding of assent of so-and-so without providing any reason for such delay is unconstitutional, illegal and arbitrary. So another thing, my lord, the governor has to give reasons that this petition presupposed. Then, my lord, third is also, my lord, on the same ground. My lord, it is based upon or at least inspired by, my lord, one recent decision, my lord, of this honorable court, my lord. My lord, and I have prepared, my lord, a summary. My lord, first and foremost, under Article 145, this question, my lord, raises a constitutional question of importance. Now, that is a settled law. It has to go before the 5 judge. That's the mandate of the Constitution. Second, if my learned friend were to rely upon the judgment delivered by a 2-judge bench, my lord, this is how, my lord, I am demonstrating that that judgment is contrary to and not, my lord, in my respectful submission, in tune with several constitution bench judgments. They are relying upon a judgment, my lord, at page C, State of Tamil Nadu versus Government of Tamil Nadu and others. This is their case. Their fundamental foundation of the case is that judgment. Please turn to page 3.
Can I? This strange procedure.
But these all issues will be decided by the.
It should be deferred to 1 minute.
Correct, my lord. So I have no difficulty. But, my lord, my respectful submission is, my lord, let this be decided, my lord, along with issues are the same.
Now, can I say?
Issues are identical.
Can I say something?
That was a presidential reference.
Basically, we will be answering the reference made by the president.
That's
correct, my lord. But is my learned friend giving up the preliminary contention in presidential reference?
Can I respond? No,
Can I at least complete my arguments? My lord, I have no difficulty. Please refer this to a constitution bench and hear it after presidential reference. But this has to be heard by a 5-judge bench. You know, that's the mandate of
Now, I have to
constitution.
reply after this. I have filed this writ. In my writ, my learned friend on Thursday moves this IA. It is, of course, separate matter is moved without notice to me. Can I please finish? No, of course, that's very important for me. You move an IA on Thursday without serving me. The IA seeks dismissal or allowance of my writ that your lordship will decide. This matter should be simply deferred without any comment. I have to file a reply to this IA. He has given me a note just now which is not even in his IA. I will, of course, file a writ based on the law of the land today. If in an advisory opinion, your lordship changes the law of the land, we will abide by that. What is the point of moving an IA in my writ? Saying,
that statement be recorded.
Bench. I am saying nothing. I am going to reply to this IA.
Bound by whatever is.
That's right.
Certain.
Once the constitution bench decides it, The other bills would also be bound to follow.
Sir, please, my lord, my learned friend statement may be, my lord, checked. Para 4 of my IA. I am not praying that dismiss the IA, dismiss the main petition. I am saying refer the caption writ petition to a constitution bench.
Of course, I'm objecting to that.
Of this honorable court to decide the substantial question of law as to interpretation of the constitution.
So what will happen
For a
is-
3-judge bench, my lord, I can always, my lord, say that the 2-judge bench judgment ignores.
Once we decide the presidential reference.
Yes, my lord.
These issues would also get resolved.
Certainly, my lord, but kindly refer it. Your lordship can hear it separately.
Await the reference.
No, my learned friend wants.
The constitution bench decides it.
That's right.
Directly, indirectly, this issue. The matter will be covered by that.
Why is this IA filed? To convert the presidential reference
I
to reference.
have so many matters there and so many lawyers.
Yeah,
why do you want to get 2 briefs for Dr. Singhvi in one book? As it is, you will be representing.
Very brief, sir.
As you will be representing at least 2 or 3 states.
No, I am representing only central.
I'm talking about the Dr. Singhvi.
No, minimum.
I can tell you, Lordship, my learned friend is having many more briefs than I will in that matter starting tomorrow.
Well, in fact, on the first day I had appeared, even before we opened, my lords had said, my lord, the Chief Justice had said, this will await the outcome of the advisory. That's what your lordship yourself had said it.
The matter to come up after the presidential reference is decided.
Grateful, my lords.
In item 21, my lords, the office report indicates that the respondents have not been served, my lords. I had filed the process fee and my lords served by email. My lords, if my lords permit me some time, I will once again serve them, my lords. If my lords can give me the liberty to serve by email, my lords, I've got some fresh emails. I'll make service again. 2 of the respondents, my lords, are based abroad. And my lords, 4 of them are in India, my lords, Bangalore. So I'll serve them by email if my lords permit.
So respondent through email in addition to normal mode of service.
So I can serve by email, my lords?
Yes, sir.
Grateful.
Lord, in item 22 also, Lord, we are facing some difficulty because as per the Geneva Convention, Lord, the province of Ontario does not have an online payment link, my lord. So what is required now is, my lord, a traveler's check, my lord, drawn on Canadian bank, which is why, my lord, we could not take steps. My lord, I am also seeking only 4 weeks time, my lord, I will take steps in item 22.
Item number 25, my lord. Lord, I am for the respondent, my lords. My lord, kindly allow me to file the reply, my lord. It is ready, my lord.
My lords, item 45, I may be granted liberty. It's a matter in which it is in mediation with respect to one respondent. Settlement is there. It's for quashing. And my lords, we're just seeking 2 weeks adjournment, my lords. Maybe my lords may give a specific date for 8th, my lords. We are nearing, it will come to conclusion in the meanwhile, my lords.
Item 46, my lord, I mentioned got listed today, my lord. It's not reached. So can it be on Friday?
Lords, in item number 36.2, my lords, a direction may be passed that no coercive action may be taken. Lords, I'm going to be released today. And item 36.1, similar direction has been passed, my lords.
What do you want?
That no coercive action be taken till the
not without
petition is pending.
My lord, item 27, there's emergency, my lord.